And how long have you been with Georgia State Patrol?
Approximately 3 years.
And what are your current duties and responsibilities?
Enforcing traffic laws, criminal laws, working traffic accidents, fatalities, and assisting other agencies when needed.
And are you post-certified?
I am.
Can you please explain to the jury what post-certified is?
I have my credits to having no credits to I went through the academy, took all the classes needed to carry a firearm and enforce the law.
And in your employment, have you had any type of training?
I have.
And what kind of training have you had? Let me ask this. What kind of training have you had that's relevant to this case?
Field sobriety training.
And in that field sobriety training, did you have to pass a test to get your certification?
I did.
And did you pass your test?
I did.
All right. Throughout your training, have you had the experience to detect the smell of alcohol?
I have.
And how often do you come across that?
Pretty often. Coming in contact with people every day. So.
And were you working on the night of May 29, 2022?
I was.
And were you in full uniform, including your badge?
I was.
Yeah, and were you in a marked patrol vehicle?
I was.
Did you ever investigate a case involving the defendant, Mr. White?
I did.
And do you see him in the courtroom today?
Yes, I do. Yes, I do.
And could you please point him out and describe something he's wearing?
Feel free to stand if you need.
It's like a blue suit. Like blue suit. Bald head, black man.
And Judge, for the record, let the record reflect that the witnesses identify the defendant in the case.
All right, it will so reflect.
When did you first become involved with Mr. White's situation?
That morning of, it was May 29th.
Around what time?
5 o'clock, approximately around that time.
And how did you make it to the location?
I was working midnights and I got called to a traffic accident, 85 North. I think it came out like near 400, but it was on like Beaufort Highway area in between the middle of 400 and Beaufort.
And what county would that be considered?
Fulton County.
Okay. And when you arrived, or I guess, how did you hear about it?
I got called from my communication center to respond to an accident.
Are you aware of who reached out to the communication center?
Atlanta Police Department did.
Okay. And so when you arrived, what did you observe?
Put up on scene. I seen multiple lanes being blocked by Hero, Atlanta Police Department and Fire Department, and I seen several vehicles scattered over the roadway. I believe Mr. White was driving a Chrysler 300, and then there was a truck to the right, and then there was another vehicle.
And when you arrived, did you speak with anybody from APD?
Yes, I did. APD Officer Lane, when I got on scene, he briefed me on the situation about what happened and why I was called out.
And what did he tell you, if anything?
Accident had occurred. Driver, Joshua White, was the driver of the Chrysler in the middle of the roadway, and it was a mess out there.
And when you say a mess out there, can you describe the damage to the vehicles?
Disabling damage, I believe, on all 3 vehicles. They were towed away from the scene.
So you wouldn't classify it as would you classify it as a fender bender?
No, not the way those vehicles were messed up, no.
Now, did you ever speak with Mr. White?
I did.
Okay. And when you spoke with Mr. White, what, if anything, did he say?
After I spoke to Officer Lane, I approached myself to Mr. White, asked how he was doing. I said if he needed any medical assistance due to the severity of the scene. He said no. And then after that, I went into field sobriety.
Why'd you go into field sobriety evaluations?
I was notified that when APD officer pulled up, Mr. White was pouring alcohol from another cup onto the roadway.
And did you observe anything about Mr. White's person that led you to believe that a field sobriety evaluation was warranted?
When I approached him, a little bit swaying, and when I talked to him, strong odor of alcoholic beverage was emitting from his breath.
And was he away from the vehicle while you were speaking with him?
He was, I believe he was like right in front of his hood of his vehicle. So standing in front of outside.
Okay, and so would you say that the smell of alcohol you were smelling, was it coming from the vehicle or was it coming from him?
It was coming from him.
What are field sobriety evaluations?
Evaluations I go through to um or, um evaluations I go through to what am I trying to look for?
It's okay. We all have those moments.
Look for clues of impairment. I'm sorry.
And what are clues of impairment? What do you mean by that?
Intoxication of an individual. So when you say can you rephrase the question?
Well, let me ask you this. What are the 3 evaluations that you performed on Mr. Whitehead?
Before I started, I medically cleared him, and then the 3 parts can pertain to field sobriety is lack of smooth pursuit, distinct nystagmus at maximum deviation, and nystagmus, onset nystagmus prior to 45 degrees.
Okay, so I'm gonna back it up a little bit.
Okay.
So when you say medically clear, why do you medically clear someone?
To see if they have nystagmus before I start the exam.
And so which examination are you speaking of now? So you gave me 3 things: distinctness, distinct nystagmus, maximum deviation at 45 degrees, and onset of nystagmus. What evaluation are all of those under?
HGN,
Okay.
horizontal gait nystagmus.
Okay, so the first test that you performed was HGN. which
Correct.
Consisted of those 3 things.
Correct.
So when you medically cleared him, what exactly did you see when you were performing that evaluation?
Involuntary jerking of the eyes, which would be nystagmus.
Okay, so that involuntary jerking of the eyes, what is that caused by?
Intoxication, alcohol.
Alcohol. So okay. So when you performed this evaluation, where did you have the defendant stand?
He was doing it. I did it in front of his car initially. Then I brought him for a closer view in front of my camera. I brought him in front of my patrol car, and then I examined it.
Were you wearing a
Examine
body
him.
worn cam that evening?
I was. We have a mic. Yes, I was.
Okay.
Along with my
And
dash cam footage.
showing defense counsel was previously marked as state's exhibit number 1. The dash cam. Yes, ma'am.
Okay.
Yes, ma'am. This state would like to approach the witness, please.
Okay.
Trooper Fernandez, can you please tell me what that is?
Exhibit number 1 has Joshua White's name, and then has my name with initials.
Do you know what it contains?
I believe it's footage of my evaluation of Mr. White.
Excellent. The state would like to tender in the state's exhibit 1, the dash cam and mic pack of Trooper Fernandez.
No objection.
All right, submitted.
All right, may we publish?
Yes.
Your Honor. So, Trooper Fernandez, I'm going to have you explain to the jury as we're watching each of the things you just told us.
Okay.
Judge, okay, never mind. Sorry, having a couple technical difficulties.
That's okay.
One second, Your Honor. So I'm gonna have to play it from directly from the stream online, so it's gonna be a little bit choppy. I do want to make everybody aware I'm not able to play the downloaded version. And we are gonna start by skipping ahead to 5 minutes. So I'm gonna pause really quickly. Can you tell us whose car is where? Or I guess, can you tell us where Mr. White's vehicle is?
Mr. White's vehicle is right in front, well, right behind of all three of the people you see with the reflective vest on.
Okay, so if you wouldn't mind standing up and just pointing out.
Oh, sorry.
Yeah, watch your head. Okay, awesome, thank you. So at this point, who are you speaking with?
Officer Lane of the police department.
So for the record, for a little bit of timeliness, I'm gonna move forward a little bit to 7:20. 7:16. So stopping at 8:10 for the record. Maybe. So stopping at 8:10 for the record. That's why, there we go. What was that conversation that you had with Mr. White there?
I medically cleared him to see if he was able to perform field sobriety evaluations.
Okay. So at this point, are we getting ready to begin the HGN?
Yes, we are.
Okay.
Your Honor, is it possible they could be told to quiet down? It's just.
I thought it was
hard to
just me
hear.
hearing it with my
No, it-
hearing aids on.
Get that frequently. Where's-
Deputy Parker. Thank you. Deputy Parker, yes, ma'am.
Wondering if we could get the speaker like turned towards us. so
Oh,
we
can you turn the speaker? There you go.
They don't mind.
Deputy Parker, can you ask whoever's in there to kind of simmer down a little bit since we're having a trial? Is it the detainees or is it lawyers? Hmm,
It's like a term.
yeah.
Yes, it's true.
Thank you. Thank you, Deputy Parker. All right, go ahead.
All right, for the record, starting back at 8 minutes and 5 seconds on the video. Well, now we don't have sound at all.
Did you make sure you click the little include audio?
Yes, ma'am, I did.
Yeah. May have to stop sharing, go back and try it again.
Bottom corner, bottom corner, bottom right corner, it's got an X on the.
Oh, it was covered up by my screen, that's why. Thank you. And it's still on there.
on.
Feet together. Arms right side, right? Look at tip of my pan, move your eyes and your eyes on you, not move your head, understand? All right. That was a question. Sir? Do not move your, you understand? Move your eyes only, not your head. Yes, sir. All right. 12 to 15 inches. Come on my vehicle. Come on my vehicle. All right, you go right there. Stand right here. Left side. Left side, left side, left side. Yep. All right, you get right there. All right, same thing. All right. You tip my pen? Eyes only, understand?
So while we're watching that, in that first step that you did, what were you checking for?
First step I was checking for equal pupil size and equal tracking.
Pausing at 1026, why do you check for equal tracking and equal pupil size?
To see if there's any resting nystagmus, which is involuntary jerking of the eye.
Would that be indicative of any type of acute injuries?
Yes.
If it was present?
Yes. Correct.
Okay. So when you failed to observe those particular things, did that mean that there was no head injury from a perspective of field sobriety evaluations?
From my knowledge, yes.
Okay.
Eyes on.
Why do you have to keep telling him eyes only?
He keeps moving his head. Moving his head.
Did you instruct him to not move his head?
I did.
And is that indicative of somebody who, or I guess, is that failure to follow instructions
All right, so next evaluation
common in people who are impaired?
Walk and turn.
It is.
Stand right there. I want you to imaginary line on the ground. You see one? It's imaginary line.
Stopping for the record at 11:36. So how many possible clues can you observe on this first evaluation, the horizontal gaze and stagmus?
6 total.
How many clues did you observe in the defendant that evening?
6 total.
What's the next evaluation you performed?
Called the walk and turn.
Explain to the jury, please, how the walk and turn works, or how you instructed on the walk and turn.
Due to my training.
Okay.
As in,
And what are the steps of the walk and turn?
okay. So as I position Mr. White in front of my car, or anybody in front of my car, or if the ground is level enough to imagine the imaginary line, put your left foot on the front of the imaginary line, put your left foot first on the line, then put your right foot in front of your left foot in the heel to toe manner, arms by your side, and just stand there until I give you further instructions to move. At that point, when I give you instructions to move, so you take 9 heel to toe steps up your imaginary line, and then when you get to 9, leave your lead foot on the line, taking a series of small steps, coming back around, taking 9 more heel to toe steps back down your line. I instruct you to look down at your feet, count out your number of steps, keep your arms by your side, and don't stop until you are finished with the test.
How many total clues are there in that particular evaluation?
8.
All right. So starting at 11 minutes and 36 seconds for the record.
You see the imaginary line on the ground? Yeah, just imagine. Yeah, just imagine a line. Okay. You got it. Put your left foot at the beginning of that line.
Start with my left foot?
Yep. Left foot at the beginning of the line. No, wait. Hold on. Put your left foot at. You got your line? Just imagine a line. All right. Put your left foot at the beginning of the line. Put your right foot in front of your left foot, heel to toe manner. Starts too early. All right.
Listen,
Now just follow.
can I ask you what's going on right now?
I'm just evaluating, make sure you're able to drive. Not obviously drive, but
Obviously, yeah.
follow directions. All right. Follow me. See, this is my line. You got your line? Put your left foot in front. Put left foot on the beginning of the line. Your left foot. Follow. Put your left foot on the beginning. Yep. Put your right foot in front of your left foot, heel to toe. Stay just like that. Put your hands by your side for me. Stay just like that for me, all right? All right. What I want you to do when I tell you to begin, I want you to take 9 steps up your imaginary line. I'm gonna demonstrate. In the heel to toe manner. 1, 2, 3. I want you to take 9. When you get to 9, leave your lead foot planted on the line, take a series of small steps, coming back around, taking more 9 heel to toe steps back down your line. 1, 2, 3. I did 3, I want you to do 9, all right? But when I tell you to begin, hold on. Would you look down while you walk, count out your number of steps, keep your hands by your side, and when I tell you to begin, don't stop until you are finished.
Okay.
You have any questions?
No, sir.
All right, go ahead.
1, 2, 3,
Miss heel to toe.
4, 5, 6, 7, 8,
Missing heel to toe.
1, 2, 3, 4, 5, 6,
Steps off
7,
line.
8, 9.
All right. Last evaluation. Called the one leg stand.
All right, so when you were talking into your mic pad, what were you doing?
I was stating the clues that Mr. White was messing up on.
Okay, and so every single time he missed a heel to toe, for example, because I heard you say heel to toe quite a few times. Do you count every single time that he misses heel to toe?
No, I just said that so I can remember.
Okay, and so how many total clues did you observe for this particular evaluation?
5,
And out of the, how many?
8.
Okay, and so those 5 clues, were they all unique individual clues?
What do you mean you say that?
So you didn't count 3 missed heel to toes. It was, he missed heel to toe a bunch of times, and that was 1 clue.
Correct.
Okay. Do you perform these evaluations on people who don't get arrested?
I do.
So not everybody that completes them is considered under the influence to the extent they're less safe when you do these evaluations.
Correct.
Okay. What's the next evaluation that you perform?
That's called the one leg stand.
Can you please explain to the jury how the one leg stand works?
I get up and demonstrate it. But
If,
Like
well, we're
that-
gonna see it on there, so just if you could explain instruction wise what you would tell him.
so I tell you to do is stand up straight, put your feet together, arms by your side. Then I tell them put your feet together, arms by your side. Lift the leg of your choosing, left leg or right leg, whatever feels more comfortable. Lift it up approximately 6 inches off the ground, parallel to the ground, keeping your leg straight. Keep your leg straight. Eyes looking at stand up. Keep your leg straight. Here's by your side. Pick whatever leg feels comfortable, left leg or right leg. Approximately 6 inches off the ground, parallel to the ground. Yeah, keep your toes pointed forward. Keep your hands by your side. Count out in the manner of 1001, 1002, 1003. Look down whatever leg you decide to choose. Count out in the manner 1001, 1002. Keep your arms by your side. And if you drop your leg, it's all right. Pick it back up. Just continue. It's all right if you drop your leg. Pick it back up and continue counting till I tell you to stop.
All right, so how many total clues can you observe on this particular evaluation?
4.
4. And how many, well, we'll get to that in just a moment. So for the record, starting at 13 minutes and 46 seconds.
Put your feet together for me. Hands by your side. All right, watch me. What I want you to do, I want you to lift the leg of your choosing, left leg or right leg, whatever feels more comfortable, approximately 6 inches off the ground. Keep your foot parallel to the ground. Keep your toes pointed forward. When I tell you to begin, I want you to lift whatever leg you decide to choose. I'm lifting my right because it feels more comfortable. I want you to look down at your leg, count out 1001, 1002, 1003. So I tell you to stop. Keep your hands by your side, and if you happen to drop your leg, just pick it right back up and keep counting.
Okay. How long?
I'm gonna tell you when to begin. Do you have any questions before I tell you to begin?
No, sir.
All right, hold on. Hold on. Begin.
right.
All right, you're good.
So what are the clues you can observe on that particular evaluation?
He lifted his arms to balance, put his foot down, was swaying.
And so how many total clues did you observe in Mr. White with that evaluation?
3.
At this particular time, Trooper Fernandez, had you made any conclusions?
I did.
What conclusion did you come?
He was intoxicated.
What was the next steps after that?
I placed him under arrest for DUI.
And once you placed him under arrest for DUI, what did you do?
Put him in the backseat of my patrol car, and then I read him implied consent for suspects age 21 or over. A green card that I read gives you the option, whether you want to or not, to take a state administered chemical test of your blood, breath, or urine.
And what did you request in that particular night?
I requested for blood.
And what was the defendant's response?
No.
Where did you take him after you all, I guess, left the scene of the incident?
Grady Hospital to get cleared,
So,
if I'm not mistaken.
and did they clear him? If you need to refer back to your.
I do. Oh, real quick.
refresh your recollection. May I approach your honor?
Yes.
Well.
I have notes. Can I
What's that?
look at my notes real quick?
Yeah,
Okay.
You have it. Ms. Berry, you
Well,
need to look at what he's
I was
looking
about to
at?
say his notes are,
I'm familiar with it.
okay.
Okay, go ahead.
Yes.
So, has your memory been refreshed?
Yes.
Okay.
No, I
So,
just to
when
get
you-
it cleared.
When you took him to Atlanta pretrial, which was at Grady Hospital, where, or I guess, what was the outcome of that visit?
Just to be medical cleared due to the fact that he was involved in a traffic accident.
Okay, and then where did you take him after that?
Atlanta Pretrial Detention Center.
Okay. All right, 1 second, Your Honor. So I just want to go back to the beginning portion of your testimony, just really quickly. When you were speaking with Officer Lane, did he tell you how big the bottle of liquor was?
Yes, I was advised.
And how big was it?
Put up objection hearsay.
He was on the stand yesterday and testified to it. He was available for cross-examination, Your Honor.
Yeah, I'll allow it.
How big was it?
1.75 liters.
What kind of liquor was it?
Casamigos.
And have you ever seen a 1.75 liter bottle of Casamigos?
I have.
Okay, and Judge, for demonstrative purposes, the state would like to introduce State's Exhibit number 1. It is a demonstrative example of the bottle. I know we discussed the judicial notice with the thing, but I wanted the jury to be able to a complete understanding of it.
Okay, is that gonna, actually, the video is number 1.
I'm sorry, State's Exhibit number 2, excuse me.
All right, any objections?
Yes, again, hearsay. This was something that was not observed by the trooper. This was observed by the other officer.
I'm using it for demonstrative purposes. I do have case law to say that it does not have to be the exact, and it can be for demonstrative purposes. And if Your Honor, may I approach with case law
Sure.
very briefly? And I do have a copy for defense counsel with relevant portions highlighted. And if you look on page 7, Your Honor.
Either one, sorry. All right,
On page 7, Your Honor, the burden is on the party to offer demonstrative evidence to lay a proper foundation, establishing a similarity of circumstances and conditions. Now, Your Honor, the state has introduced through Officer Lane the size of the bottle, the fact that he observed it. We also have brought up through Trooper Fernandez that was familiar with the bottle that that Officer Lane told him about. And he has experience with knowledge of the size of the bottle, and he has seen one before. Thus, I think he can authenticate that this is a 1.75 liter bottle of Casamigos.
Ms. Berry?
Again, objection, Your Honor, it's a speaking objection. I mean, he's already made the point to the jury, so.
Okay, well, I'm going to allow it because he did say it was 1.75 liters. I mean, that's what he recognized that added, and that's for the state, that's a 1.75 liter bottle of Casamigos. So I'll allow it for demonstrative purposes.
Thank you, Your Honor. May we publish?
Yes.
So. No further questions for this witness, Your Honor.
All right, Ms. Berry, cross. Everybody good? No one needs a break, right? Everybody good?
Good morning.
Warren.
Okay, so going back to where you started your testimony. So you said in May 2022, how long had you been involved in law enforcement?
Approximately, at my current job, you state,
Well, I guess you said as of today, you've been in law enforcement about 3 years?
yeah, no, approximately about 3 years.
Okay, so were you pretty new at the time that this happened?
I was.
Okay. When did you complete, like, I guess, trooper school?
Started in October, graduated in April of 21.
So you started October of 21 and graduated in April of
I'm sorry, I started October 20, graduated in 21,
21.
April 21.
Okay. So when this happened in May of 2022, you'd been a trooper about a year.
Yes, yeah, no problem.
Got it. And I guess in your role as a state trooper, you do a lot of traffic enforcement, right?
Correct,
And have you work a lot of accidents?
correct.
Do you have any specific training in accident reconstruction?
I do levels 1 through 5.
And when did you get that training?
It was spread out. I believe I completed 5 beginning at the end of last year. I finished level 5.
Okay. So, but you didn't actually investigate the crash in this case, right? That was
I didn't.
the Atlanta police officer who did that?
It was.
Okay. So you were not involved in that part of it at all?
No.
And you did not actually see the accident, you just responded after the fact, right?
Right.
And at this point in time, when you did this investigation, how many DUI investigations had you done at that point?
This was my first one.
First one, okay. And I guess but you've worked a lot of wrecks now over the past 3 years. In your experience, is it pretty typical when someone is in a car accident, whether big or small, that they can have an adrenaline rush, be kind of shaken up?
Yes.
That's pretty common. And it's also pretty common that people might not necessarily know the full extent of their injuries when they're initially in an accident, right?
Correct. I'm not a professional, but I'm assume so.
Right. And to your knowledge, Mr. White was not evaluated by a medical professional on scene, right?
He refused.
He said, no, he's good.
Yes.
Okay. Though you mentioned that you medically qualified him before doing the test of his eyes. What did the medical qualification consist of?
Asked him if he had anything wrong with his head, neck, back, legs, or anything of that sort before I administered the test, and he stated no.
Okay, so it was basically just asking him.
If he was
Right.
okay.
Okay, so it was not like a medical test that was done.
No, ma'am.
Okay, all right, very good. And you would also agree with me that you've investigated plenty of accidents where there's rear end collisions, right?
Correct.
And a lot of them have nothing to do with alcohol or drugs, right?
Yeah, well, I will draw.
Can you restate the question?
Many motor vehicle accidents are just because a driver is distracted, not having to do with alcohol or drugs, right?
Depends on the situation. Depends. Yeah, it just depends on what I roll up on.
Okay, so every accident you roll up on usually involves alcohol or drugs?
No.
No, okay, all right. All right, so let's talk about then the tests. Well, I guess, so you're there to do a DUI investigation. And this was you were wearing a mic and you had the camera, I guess, was in the dash of your car. Is that right?
Yes, I have body mic. Yes.
Okay. I guess let me ask you, did you ask Mr. White, I guess, where he was coming from and where he was going?
I did not.
Did you ask him what he had to drink that night?
I did not.
Did you ask him what he had to eat?
I did not.
Did you ask him who he was with?
I did not.
Did you ask him how long he had been up, how long since he last slept?
I did not.
So you didn't really ask him any questions before starting these field sobriety tests, right?
Correct.
And don't you think that would have been important information to ascertain?
Yes.
All right, so we get into the field sobriety test. So you said you asked him, hey, do you have any problems, medical problems? And he says no, right? Correct?
Correct.
And then you said you determined that he didn't have any concussion or head injury because you did a pass and his eyes looked okay? Did I understand the testimony correctly?
You say that again, I'm sorry?
I guess, how did you rule out the fact that, well, is it your understanding his airbag is deployed?
Yes.
And how did you rule out the fact that he had hit his head or had a concussion or anything of that nature?
Just looking at him, he wasn't bleeding, no bumps on his head.
Okay. So you can't say with any certainty if he did have some kind of head injury, right?
Not internally.
Because you don't, I mean, you don't have any medical training, right?
Correct.
Okay. All right. So let's talk about this first test, the horizontal gaze nystagmus. So you said you're looking for jerking of the eyes, right?
Correct.
Now, did you learn in your training? I guess there are many other kinds of nystagmus that exist in the world, right?
Correct.
What are some of those other kinds of nystagmus?
And then we got vertical and excuse me. Vertical's on I can think of
Okay.
right now.
I know before you mentioned resting nystagmus. So nystagmus just means a jerking of the eyes, right?
Yes.
So some people always have resting nystagmus, right? Like their eyes just jerk naturally.
Correct.
And what about, are you familiar with optokinetic nystagmus?
No.
You didn't learn about that in your training?
No, not that I
You ever
recall.
learned in your training about nystagmus that's caused by flashing lights?
Yes,
Yes. So is it a good practice to usually to turn off lights, right?
it is.
Yeah, okay. Or what about, are you familiar with fatigue nystagmus?
Yes.
And, or caloric nystagmus? Or I guess, are you familiar with any nystagmus that's associated with conditions, medical conditions with the inner ear?
Jake's actually here. She's, well, I asked and answered.
I'll move on. I'll move on.
Thank you.
Okay. And then you also, I guess, when you were taught how to do this eye test, looking for nystagmus, I guess there's a very prescribed way you're supposed to do it, right?
Correct.
Because if you do too many passes, if you do the passes, back and forth passes too fast or too close, that could compromise the results that you're looking for,
Correct.
right? So also too, if somebody moves their head, if they don't actually focus on the stimulus, then that could compromise the results also.
I'm sorry, can you repeat that?
If somebody moves their head and doesn't keep their head straight, that could also compromise the results, right?
Yes.
So I think you testified that he was moving his head.
Yes.
So if he did move his head, what is the remedy to make sure the test is still accurate?
When he moved it, I'm sorry, can I?
No, that's okay.
I'm sorry, repeat the question, I'm sorry.
Well, if he moved his head, did you redo the pass to look for the nystagmus or?
I stopped. I stopped, stayed where I was at, and then I told him not to move his head, and then I did the pass again.
Are you aware, are there rules though? Can you just keep doing the passes indefinitely until you see the nystagmus?
No, that's not what I was doing. I was just letting him know to just keep his head still and just move his eyes only.
but you said you're familiar with fatigue or endpoint nystagmus, which basically can be caused by too many passes, right?
I believe it's at the same time when I stop and do it again, I'm just I'm not doing it and keep telling him I stopped and then I told him his eyes only and then I continued on.
Couldn't really tell because he was faced away from the camera, but then did you do passes? So you did horizontal passes to see horizontal gaze nystagmus, but then did you do passes to see vertical gaze nystagmus?
Yeah, that was part of it.
Did you see vertical gaze nystagmus?
I don't believe I did.
Because you would have marked that in your report, right? And you did not mention that in your report?
Correct.
Correct, okay. And what is vertical gaze nystagmus?
And talk I believe when the person is very heavily intoxicated.
So it'd be a high dose, you would see vertical gaze nystagmus if it was a high dose of alcohol for that particular person, right?
Correct.
And there was no indication that that was indicative in Mr. White, right?
Correct.
Okay. All right, let's talk about the walk and turn evaluation next. So that's when we take, you said, well, I guess there was some issue where he started too soon.
He did.
Is it considered a clue of impairment if they start before, like you say go, right?
It is.
So is that one of the clues that you indicated made you think he was under the influence?
I believe I marked that correct.
So they are supposed to, well, I guess, would you agree with me that outside the test, Mr. White appeared to have a normal gait? He was standing, he was polite, he wasn't giving you a hard time, he wasn't falling over, right?
He was swaying. He was swaying.
Okay, all right, so you're saying that he was supposed to wait in ready position? So what is ready position?
So he was supposed to imagine a line in front of him, put his left foot on the beginning line, and then put his right foot in front of his left foot in the heel toe manner.
And then he's supposed to wait for you to demonstrate, or he can't?
I apologize, Jack, this is kind of testifying.
Yeah. You're testifying with your movements.
Oh, okay.
If you want him to demonstrate, okay.
Understood. So he is supposed to wait in with heel to toe. And then you tell him to go. Is that accurate?
Yes, I demonstrate. Wait in that position, then I demonstrate so he knows I could do it while I'm explaining it, and then he starts the evaluation.
She was able to walk in a line, make 9 steps, turn around and walk back, right?
He did with some clue with also missing parts of the dam. He like stepped offline, and 3 clues that he did miss.
But I guess there's a total of 18 steps, right?
Yes, back and forth.
So how many steps did he make correctly and how many steps did he not make?
I believe from my notes he did 9.
He did
I'm sorry, he did 18 total.
18 total. Okay. But I'm saying, but so most of them were heel to toe, right?
He missed some. He missed a few during those 9. I don't know at what point he did, but that's why I was narrating to my mic when he did miss it.
So would you agree that I guess since this is a standardized evaluation, you don't factor in if somebody is naturally clumsy, if somebody is nervous, if somebody has different health conditions. It's all scored the same way, right?
Yeah, when I medically cleared him, he said he was fine. So.
And then let's talk about the turn. So if somebody does 9 steps and they just get to the end of the line and they just turn around in a regular way, that would be a clue of impairment, right?
Yeah, that's wrong because I didn't say turn how you would like. I take a series of small steps coming back around.
So they're supposed to keep 1 foot planted and then take a series of small steps around?
Correct. Back to their line and walk back down.
So it's sort of like a spin type turn they're supposed to do.
I would indicate it's like a slow turn.
So it's, I guess the way you're asking the person to walk and turn is not the way somebody typically walks and turns, right?
Depending on how somebody walks and turns.
Right, okay. All right, let's talk about the 1 leg stand. So he clearly had trouble doing the 1 leg stand. So can you go over the instructions again? Someone is supposed to, with you timing them, right?
Correct.
An officer timing them, they're supposed to keep arms at their sides
Ms.
and,
Berry,
and lift 1 foot at least 6 feet off the ground minimum.
Yes, 6 inches,
they're-
6 inches off the ground.
And, and then they have to keep their leg straight out
Yes,
and their toe pointed
forward, correct.
or, okay. And then what did you say? They're supposed to keep their head back or look at their,
No, I told him to look at whatever leg he decides, he chooses to lift, left or right, whatever feels more comfortable to him.
okay. And would you agree that there are some people who would have a hard time doing this, stone cold sober in their on their birthday in their backyard with their friends around? That this could be nerve wracking for people.
Lifting your leg. I'm sorry. Can you rephrase the question? I'm sorry.
That this could be hard for some people, just might be naturally clumsy and have a real hard time doing this.
Sure, I guess.
And you would agree this is a stressful situation. There's lots of police cars and traffic and flashing lights, right?
Speculation.
But we saw the video.
oh, what's that? He said speculation.
Speculation.
What was your response?
Well, I guess in his training and experience, I'm asking if this could be hard for people.
And in your training experience, do you know if that would be hard for some people to do?
To lift their leg.
When there's a lot
Like
going on.
One leg stance.
Would it be hard to lift? I'm sorry, I'm just not understanding.
Move on. I'll move on.
Okay.
I'm sorry.
All right. So I guess just lastly, you don't know anything. I mean, I guess there was no further evaluations with Mr. White in terms of establishing what I call baseline. You don't know about his educational level?
I do not.
Correct. Did you ask him, what I call ABCs, 1, 2, 3s, who's the president, anything like that?
I did not.
Okay. And you don't know his natural, you don't know if he's, I guess you don't know anything about him, right? Other than what we saw on that tape.
Correct.
Okay. So let's then talk about, so you placed him after the one leg stand, you placed him under arrest. And you said you took him to the police car. So he's under arrest at this point, he's handcuffed.
Yes.
And then you read him a card, you said, implied consent?
Yes, I have it if you'd like me to read it.
Okay, you want to read it because you said you asked him for a blood test. So
I
if you want to
did.
read the card that you read to him?
After I placed him and put him in the backseat of my car, I asked him how old he was, and then I wrote him the implied consent notice for suspects age 21 or over. She didn't read it.
Judge,
Yeah.
I would just ask that if she's gonna use this or memory from that it be placed into evidence first.
And he's on, yeah, or I guess I'm gonna have to keep his card though, so
If
we can make a photocopy of it.
To a photocopy of it, then I can make a photocopy before we leave.
I certainly will stipulate.
All right, we won't keep your card, we'll just make a photo.
Okay.
Okay, after the hearing, after the trial, we'll do
And if you
it.
want to stipulate as to the color of the card, just for record purposes.
Ms. Berry,
It's green.
okay, so it's green, but we'll make a non-colored photocopy
Okay.
of the card, all right? That way you won't have to give up your card.
Okay. The state of Georgia has conditioned your privilege to drive upon the highways of this state upon your submission to state administered chemical tests of your blood, breath, urine, or other bodily substances for the purpose of determining if you are under the influence of alcohol or drugs. If you refuse this testing, your Georgia driver's license or privilege to drive on the highways of this state will be suspended for a minimum period of 1 year. Your refusal to submit to blood or urine testing may be offered into evidence against you at trial. If you submit to testing and results indicate an alcohol concentration of 0.08 grams or more, your Georgia driver's license or privilege to drive on the highways of this state may be suspended for a minimum period of 1 year. After first submitting to the requested state test, you are entitled to additional chemical tests of your blood, breath, urine, or other bodily substances at your own expense and from qualified personnel of your own choosing. Then this is when I ask, will you submit to the state administered chemical test of your blood?
And you said he said no?
Correct.
And is he entitled to make a phone call or talk to a lawyer about what he wants to do?
He's not.
Okay. And would that have changed, he's already under arrest in the back of your patrol car. Would that have changed anything if he had said yes to a blood test?
If you wanted to change his answer, I would have allowed it.
No, but I'm saying you wouldn't have unarrested him, right?
No, I'm sorry, no.
You've already, okay, so, but then you take him to Grady anyway, because you want him to get checked out?
The jail won't take somebody who's in an accident. So they have to go to some type of hospital and get cleared from a medical professional before the jail will take them.
So you're allowed to get a search warrant and ask a magistrate judge to sign an order saying that he has to give blood, right?
No, he doesn't have to. I read him this, so this is his choice. If he says no, then
Right, but I'm saying you asked him if he said no, but even if he says no, an officer can get a search warrant and basically make someone give a blood test, right?
if we want to go that far, correct?
Yes, okay. But this was the end of your investigation, right?
Correct.
Okay, thank you. Nothing further.
All right, anything else from the state?
Yes, brief redirect, Your Honor.
We'll put the card in as defense one.
One more time.
I guess the card will be put in as defense one, Ms.
Oh.
Berry? Well, a photocopy of the card.
Your
Well,
defense is-
The state asked for it to be admitted. I mean, D1 is fine, but
Okay, so state three. Okay, sorry. All right, go ahead.
All right, Trooper Fernandez, so I just want to clarify, did you observe any injuries visible on Mr. White?
I did not.
And did he ever complain of any injuries?
He did not.
Did he mention anything about his head hurt?
When I first approached him, I said, "Was there anything wrong? Do you have any head, neck, back injuries?" He said he did. Then I asked, well, before the accident, he said no.
Did he ever request medical treatment?
He did not.
Okay, and did the fact that you didn't ask about what he ate or drank that
I'm gonna
day?
object to leading.
So defense counsel asked a specific question and okay, I'll
Just rephrase.
rephrase it. Yeah. Would eating or drinking have a significant effect on his performance on the field sobriety evaluations based on your knowledge and experience?
No.
Are you required to perform every single evaluation that you could?
While doing efforts,
So if she asked you questions about ADCs 1, 2, 3, are you required to do every single battery of tests?
no.
Okay. Based on your investigation on the scene and the totality of circumstances, what was your basis for concluding that he was under the influence to the extent that he was a less safe driver?
The clues I observed.
Outside of the clues that you observed, did you also base anything off of any observations that you made of Mr. White?
Bloodshot eyes, swaying, strong odor of alcohol emitting from his breath when we were talking. Slurred speech, things of that nature.
When you were in basic, or I guess when you were in your SFST training or the field sobriety training, what did they tell you about the lights when you're performing these evaluations?
They said it's best to cut them off because that could have an effect on the eyes.
And did they tell you you had to cut off every single light, or was it just certain lights that they had to cut off?
Just certain lights.
Okay, and did you ensure that your lights were cut off?
I did.
Okay. And one last thing, I just want to clarify, are you able to explain to the jury the difference between seeing results on VGN, which you said you did, and seeing results on the HGN?
So just like, VGN is vertical gaze and stagger is kind of like a jerk, a very distinct jerk up and down, while left and right is still distinct, but
So let me ask you this way. Just because you didn't see clues on the VGN, did that invalidate the clues on the HGN?
no, it will not.
Okay. No further questions at this time. I will pass the witness, Your Honor.
Nothing further, Your Honor.
I would ask that this witness not be released until after the close of the defendant's case in chief.
Okay, thank you, Trooper. You can step down and we'll, just hang out there for a little bit, okay?
Okay.
Anything else from the state?
No further evidence from the state, Your Honor.
All right. So, if I can get the jurors to step out for a few minutes, let me go over a couple things from council.
All right, for the jurors.
Then you can go ahead, Trooper. You just hang out outside for a few. All right, have a seat. All right, go over this here. Miss Berry, does your client plan on testifying?
Your Honor, can we have a 5-minute recess where I can?
Oh, we can
confer with
consult
him?
with him about that. Okay, that'll be fine. So we'll take 5 minutes. That good with everybody? And Madam Court Reporter, if you give me your email, I'll email you a copy of what I recorded on Zipsy as extra backup. So hopefully, maybe that'll help you. If there's something you can't hear.
It's on my. It's on my.
Okay.
Fulton County, I just don't have the Fulton County cards yet.
Oh, but you still have the Fulton County address though. right?
Yes.
Okay. Yeah, if you do and you want me to, I'll be glad to send it to you.
Okay, yes, thank
All
you.
right.
Yes, ma'am, he would.
Like they. I bet you. It was every.
No, not for you.
But it was like. No, exactly. It's hard to explain, but it's easy to do because you're programmed.
What? No.
What? It's no work.
It's taking 5 actually.
You scare me. Crazy man, it's it.
I did, I'm gonna
Oh,
send it to you
that
right
is
now.
dope. Yo. I thought somebody let a crazy in this.
Yeah, I didn't.
I think I was about to.
No, we're gonna do it.
But I'm here, sorry. I thought about that, I think she. I was a student at Hogwarts, but I left my robe and stuff
So, yeah.
at home because I knew. I think man, she know what it is. I love her. She's very good. Yeah, I saw it. This is strong.
Red flag.
They're in their mind. Oh, they gonna get another easily.
Not as of today.
So.
There.
Absolutely.
Cause that's the.
I'm gonna do it.
Prosecutors. I'm gonna. Nope.
So I am gonna do it. Can I give this to the court reporter?
Yes.
No, prosecutor got another. She go across. Oh, she was uploading everything. Yeah, she said everything is there, she just uploaded everything to make sure we got it.
Okay, sounds good.
So we just cover it if we need her, we'll help. We need to get in. Did she? Let's see if she knocks that before. Okay. What about say, so we can get you, the cook it good.
It's right here.
You said something? Sorry. Damn. After you're having it.
I didn't get a copy of his card. I need to go get a copy of that.
That's not, that was like a whole. I mean, you're good. Yes. I got you. Right. What is it? Or come over, remain seated.
Just a moment.
Black eyes, you know, like you I do. That's fine. You know, the time you did, I put on my bag. Council. Council.
You got Mr. Hollins?
I'm trying to figure out where he went, y'all. I think he went to try to make copies or something.
Oh, his card?
The card, yeah.
Oh, okay. Where'd Kim go?
Oh, she went there.
Oh, okay.
And I guess, Your Honor, the defense is not going to be putting up any evidence.
Okay.
So I guess we could do the charge conference.
Yeah, I'll go ahead and,
Yeah. Well, I don't know if you want to inquire of Mr. White.
all right, let's see though, Mr. White, do you understand you have the right to testify if you want to testify? No one can prevent you from doing so?
Yeah.
Do you understand that you have the right not to testify if you do not want to?
Yes,
And do you understand no one can make or compel you to testify?
yes.
Thank you. There you go. Do you understand that if you decide not to testify, the court will instruct the jury that this decision cannot be used against you?
Yeah.
And do you understand if you decide to testify that you'll be asked questions by your lawyer and the Assistant Solicitor General?
Yeah.
All right, would you like to testify or not?
No.
All right, I find the defendant has made his or her decision not to testify with a complete understanding of his rights. All right, so I've got. Oh, do you got the other curative instruction that you wanted?
Oh, yes, Your Honor. So I sent it to Ms. Clark and Ms. Davis to see if they could print it.
Oh, okay.
Yes, ma'am. That goes to the matter of court reporter.
Let me see if she's printed these for you real quick.
I had exhibit 2 and 3. I just want to exhibit 1.
Oh, it's right here.
Inmates. No, it's a detention cell back there, so, yeah, so we bring them up from downstairs. And. That's
Never knew. Thank you.
Let's see.
Just to shoot that up.
Oh, okay.
I've been in court, I see them come through here, I never.
Mhm.
Always thought we could do that all
Oh, we could hold 15 people back there. Next door is where they all go when they first get on home, they free them. Mhm. Like everybody, even the doctor that did the veneers. Or come to order, remain seated.
So stand by, she's bringing me copies of the jury charters.
Thank you.
Your Honor, I guess while we're waiting on those, I have a motion to eliminate about closing argument.
Mhm.
During Trooper Fernandez's, direct, yes, he referenced, some hearsay, you know, not in evidence, that the initial officer told him that Joshua was pouring out a cup of, you know, there was a red cup or he was pouring out a cup. It was in response to one of the questions he was asked. I would ask because I didn't object to it at the time because I thought I would have drawn more attention to it. I would ask that the state not argue that point or bring up the cup in closing.
So I think in reference to anybody pouring or emptying liquids out of a cup, because I kind of have the same thoughts on that. I thought pointing that out might have made it a little bit worse. But Officer Lane did mention that he saw the red Solo cup next to the car. So I think we should be able to reference the cup itself, but not the fact that anyone was pouring anything out of it.
Well, again, just because of that coming into evidence, I mean, I don't know what I guess the state could say yes, that there was reference. I mean, that wasn't evidence that he saw a cup.
So just he
just-
saw a
just-
cup,
Yeah, just that there was a cup, but I don't want them to make any then.
leaps to pouring
leaps of,
stuff out.
You know, that he was
So,
walking around with the cup or drinking from the cup, or that was seen by anyone at the scene.
all right, so you could mention that he saw a cup, or there was a cup by the car, but nothing about pouring or tossing or what have you.
Understood.
Thank you,
And
Your
I do want to clarify that any inferences that the state draws from that are still appropriate, such that that cup came from his vehicle. Not saying that he was drinking it, but the cup being next to the vehicle right after the accident, it was observed by the officer. I think it is appropriate to make that inference. And I just want to make sure that we don't have any issues during closing with that.
Ms. Berry?
Again, because of the hearsay coming in, I just feel like I would ask that the state not be permitted to talk too much about the cup, other than, I guess, there was a cup observed on scene, which is what the initial officer testified to.
I mean, I guess they can infer.
Because, I mean, we didn't see him consuming any alcohol, but the officers did smell the odor of alcohol, which would allow us to make that inference that he consumed alcohol. So I imagine it would be similar to that, in that there was a cup next to the car.
What's your plan? What are you gonna say about?
Well, I mean, about the cup in general, that's another observation in the totality of circumstances that led the officer to believe that a DUI investigation was necessary. I'm not gonna get up there and say, oh, he had that empty Solo cup. And I mean, even in the reports, it specifically says there was a red ring, a smoothie-like ring around the cup. So there were clearly contents in the cup, but I'm not getting into all of that. All I'm getting into is that that was another initial observation that led to the development of the probable cause for the arrest for DUI.
Or for APD to call the.
Or,
trooper
yes,
to
for
do
APD
that.
to call the trooper, correct, yes, ma'am.
Okay, well, allow that, but tread lightly.
Yes, ma'am, will do.
Yeah.
So I guess we can go ahead and bring them back in
Yes, Your Honor.
and let them know that he's not gonna, the state rests. And then we'll,
Yes, Your Honor.
she's printing out some jury charges, okay? How about we do that? Do you want us to dismiss the trooper?
One more time.
Just I mean, you're gonna rest, right?
Yes, so you want,
So
yes.
I'll tell you, why don't we do this? We'll bring them in. You can rest, we can release the trooper. We can let them hang out back there and then we'll do our charge conference real quick. And then before their lunch gets here, hopefully can come in, charge the jury, you can do your closing arguments. Is that good? Kind of keep it moving?
Ready?
Man,
I just want to keep it moving. What do you think?
us
Mr. Beard?
too.
I hate just sitting here and doing nothing.
Ready?
Yes, ma'am.
All rise for the jurors. All jurors accounted for, Your Honor.
All right. Mr. Holland, you recognize this is your jurors?
Yes, Your Honor.
All right,
This is the
and
state's jurors.
Ms. Berry, you recognize these folks as your jurors?
Yes, Your Honor.
All right. Let's see, anything else from the state?
No, Your Honor, the state rests its case in chief.
All right, Ms. Berry, anything from the defense?
The defense rests.
All right. You can tell the trooper he can be excused. No one has objections, right, to the trooper?
No.
No objection.
All right, you gave him back his card. Okay. So what we're gonna do right now is go over some jury charges. I think I probably got about, let's see, 10 pages. So we'll let you folks sit back there. Have they gotten your lunch order? Okay, we'll let you sit back there. They've called that in. So as soon as we're finished, which it shouldn't take too long, we'll bring it back in. I'll charge you folks with your job. They'll do their closings and then we'll let you go deliberate, okay? And in the meantime, don't talk about the case yet until you've heard everything, all right? Thank you. Anything?
Questions?
You have questions? Okay. All right. So if you folks want to step back out, we'll go over the jury charges and then we'll get you back in here.
All rise for the jurors.
That's it. Okay.
Thank you.
All right.
Should get it out.
So, Ms. Barrett, you also got a copy of his motion for a special charge, the curative charge?
I think I'm missing a page.
From.
Page 2?
Flip it.
Oh, it's on the
Double
back.
sided.
Oh.
Yeah, she printed it front and back.
He likes to say. Yeah, for sure.
In the parts that are highlighted, these, whatever changes we want to make, we'll talk about it. Because we weren't sure whether or not he was going to testify.
Judge, under the witnesses section, it says testimony in this case will be given by witnesses who is determined an expert. There were no expert witnesses, I guess, tendered in this particular matter, so I don't know that giving that would be appropriate to the jury.
I concur. I would ask that that be removed.
So will you keep the part of the witnesses that's not highlighted, correct? Or do you want to strike I mean, you gotta have something about the witnesses. You want to strike the first paragraph?
Yeah, just the first paragraph.
And then we can strike the word expert
Yes, ma'am.
from that second paragraph, Ms.
Second
Berry?
paragraph, first sentence. Or I guess the second sentence too.
Yes.
Let's see. Okay, we'll strike the word. Or what we'll do, okay, so on the first, we'll strike the whole first paragraph, that second paragraph, testimony of all witnesses, how about that?
Mm-hmm.
So and we'll just strike that. Yeah, I don't think it. Oh, in that first sentence, you're not required to accept the testimony of any witness. Or, so we'll just say of any witness. So we'll strike except otherwise, or otherwise. No. Did you put in your order for lunch? Okay. And we'll get the jury form out here for you folks to look at. Ms. Beard, you got a copy of the state's other motion, right, for that additional charge?
I do.
Okay. Well, obviously, take off the highlights.
Right. State has no concerns with the jury charge, proposed jury charges from the court.
Okay, with the exception of the two changes we made, right? Ms. Berry?
I guess my proposal would be if where it says, starting where it says, in the state's motion for special jury charge,
Uh-huh.
where it says pursuant to OCGA, through,
No, number one on the
Yeah,
bottom,
number
okay.
one.
Uh-huh.
I guess if that be inserted on page 7, after the paragraph where it says a witness, this is under the DUI less safe charge, before we get to the possession of an open container of alcoholic beverage. That could be read there. I mean, I don't want it to be introduced as this is a special jury charge or taken out of context from the rest of the jury charge. I think it's an accurate statement of law.
So you're talking about insert it in these?
Yes,
Oh, okay. So inserted after possession of open container,
before possession of open container, at the end
Okay.
of,
right before.
there's that paragraph that says a witness who satisfactorily shows. Make that the next paragraph that says pursuant to OCGA 40-6-391A1.
So we could just copy and paste it
Just
there.
cut
as
and paste it
opposed-
right in there, yes.
And I guess we'll title it,
I would just keep it under the less safe to drive. I don't even think we would need.
yeah,
That's the right.
just
that's
add that
what-
additional paragraph.
Because I think it just kind of flows from that.
Sure. All right, so we'll take the special jury charge, put it right there at the end, just before possession of open container, right?
Yes, thank you, Your Honor.
All right, and then make sure we're okay. If you can see what I'm striking, y'all want to just look at this piece of paper, see what I struck on this other paragraph?
Maybe you approve?
Yes. Oh, and here goes the verdict form too. And I'll get Ms. Davis to make. I've read it like 4 times. And I didn't see expert. The first paragraph and then the wording in that second paragraph. You see it?
3,400.
All right, and how are we with the verdict form's good?
Yes, ma'am.
Okay. All right, let me let Kim change this real quick, so, and print out our copies, so what do you think, like 15 minutes, 10, 15 minutes, maybe? I guess 10 minutes, however long it takes for just a reprint, because you're gonna do 6 copies. Okay.
Fence is ready.
All right, be right back, Madam Court Reporter.
Wanted to be on record and everything.
When I read it, I was like, I don't like this.
Really, I think the only thing I wanted to get out. Where they gave law though.
Yeah.
But it was essentially the exact same one, as the one that I did. So it wouldn't really make much of a difference. You know, the same thing twice.
Trying to be pie. Yeah, I was.
So she remembers. I, yes, she will be back in like 10 minutes, maybe. In Judge Atline's chambers. Yes, yes, ma'am.
Sure. Hey, one thing on here that we needed to strike, and it was about the, the last paragraph of witnesses.
Yes, ma'am.
I had it marked on, but I didn't show you guys about,
It was,
that was about the sequestration rule. It was on another case. So if you look.
oh,
at
the
this-
Officer Bacon was it? Yeah, we were looking
We're
at that.
striking that.
Okay, that's, yeah, understood.
Okay. All right. How is it about? Okay. You want to come back here now? Kevin Park, you want to back over here now? Yeah, so we'll strike that.
Okay, and I'm gonna let Miss Berry know.
Okay.
We'll just wait to try to clear in the one that closes.
So, and here I am. I don't know if we can go there, but I can. I never heard of that conference. Right, do weird things. That's not a weird thing. I like that, they don't have to.
Probably,
All the time. And you're gonna see us. Where your side, exactly. And I think. But you're gonna stay. But staying the main part of the financial appetizer. Maybe I'm not that in touch with my femininity. I'm confused. Right. It's like a light mirror. Yeah. Yes, exactly.
Miss Berry, just really quickly, she just brought in, when she came back in, I just wanna make sure we're having a good person. She discussed and we talked about the witnesses. I think the last paragraph. In this case, pardon the voting sequestration, blah, 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 Officer Bacon was in the courtroom, that's from a different case, so she says she's gonna take that out.
Okay.
Yeah, so just, you know.
It love. Oh, right in our office. That's more. I just like I am. Lawyer like I changed. Not. What we hear, what Josh reading this. So I don't know.
I was like, listen, I already told you about the motion. Like, you know, for October 21st, asking for a new schedule, didn't respond. So I followed up on October 28th. But I can't follow them up, and then, she said, we'll ask the judge, she didn't reply, so this morning, I tried to. Desk. And she emailed me back. And. I was like, she said, I should have a response tomorrow, you do not have to give email. Okay, I mean, that's she like, think that one, right? Now, if you did follow on.
Right. Then it would be like.
That would be on me. I would put it in. And that's all I'm doing. And what if she has C-section? Up on the side of the road, right? And then they were talking about like getting in the weeds or something. Maybe in.
For some odd reason, but I don't.
I think he's gonna reach out.
But so then I started, and he wasn't actually really, skipping that much on the streaming part. Which I was kind of surprised. Well, and that's because the downloaded version started playing. That's why, so when I closed it out, the Safari version, or I guess the Windows Explorer, whatever I was using, I started playing the download version to the button. Yeah, it was like a 7.
She's making a copy. I'll let you folks look at, because I also put the implied consent. Y'all go over that real quick.
Your Honor, do you send a copy of the charge back with the jurors
Yes.
when they deliberate? Okay,
Yeah, so I'll have her make one if y'all mind looking at it together.
Yes.
that's fine.
And then we'll make the final changes, then I'll just make the 6 copies. Yeah. Okay, so she's bringing one copy right now.
Or if she, I mean, if I know you've already told her to make a copy. If she wants to email us a copy of it, we can just look at it on our computer. That's usually what Judge Line does, but I don't mind sharing and looking at
I
it.
don't have a computer.
I guess that would make sense. We'll look at it together.
Oh, yeah. Miss Berry travels light. Didn't you just have a baby not too long ago? Miss Berry?
I adopted a baby.
Oh, well,
But
had a
I
baby,
have-
yeah.
Yes,
I mean, I'm adopted, so, how old is the baby now?
5 months. So yeah, it's busy. And I have 3 other children, so I have 4 kids now. So
Yeah, and your
How's-
other youngest, how old are they?
they're 7, 5, and 4.
You've been out of diapers for a while, now you're back in them, right?
Yeah. Yeah.
Right. Well, congratulations.
Because you do a lot of the bond hearings, right? You deal with a lot of,
Yeah,
you have tons of attorneys in front of you, so.
yeah. I hadn't seen you in a while, though. And here is the verdict form if you both like. Y'all are okay with the verdict form, right? Y'all looked at it?
Yes.
Yes.
Okay. Yeah, night court ends November 21st, then we'll have some day slots to pick up stuff, but yeah.
So I guess you do a lot of the TPOs.
What's that?
You do a lot of the TPO hearings?
Yeah, I've handled about 26,000.
Wow.
Wow.
Jeez.
Yeah, yeah. And now I'm back to those in person, so.
See, I'm a criminal defense lawyer, so I only do those when I get roped into it as part of a case.
Yeah.
I don't,
Sitting there was going.
it reminds me why I do criminal law and not domestic law.
Right.
Like, those are the people who are like,
Or recommend.
All right, you go. You want to look over? They'll have something you want to mark up.
or do you want to look at it first or?
Oh, you can look at it first, it's fine.
Every purpose, order your lunch.
Yes. Of course.
Said, she said in the chat. And it was like, wait, you gotta leave if you want. Especially. Yes, yes. Yes. Absolutely.
I'm like, that people, I say, it's my serious every day. Every day.
We not gonna do that. I am. Yes, ma'am.
I am ready.
They're acceptable to you?
Yes, Your Honor.
Okay.
And the only thing which, the implied consent and then the.
Thank you. I added the other charge right at the end of, GUI, let's say.
Okay.
Okay, hold on.
Thank you.
Are we missing any of them?
Not that I know of. no, ma'am.
Okay, let's see. Let me see. So we got. Let's see. It's like,
Do we have stipulations in there, Your Honor?
let's see, all right. Assumption.
I guess we did only on the.
Still amended it.
Agreed. So, yeah, I don't think we need the stipulation, Judge, because I think the only things we stipulated to are outside the presence of the jury.
Right,
So I think that should be good.
let's see, then we got, let's see, presumption of innocence. We, like, let's say. Okay, so, but we still need the indictment accusation and issue of not guilty, right?
Maybe not, because. Let me see, we can change it for the- let's see.
Oh, we got the presumption of innocence. Sorry, we don't have the words about the accusation. We don't have that one. 1.10.
Yeah. I mean, it does discuss in that very first paragraph, it doesn't, I mean, it's not titled as indictment accusation, but it does talk about how he's charged with DUI, let's say, an open container, their misdemeanor, the accusation, he came in, pled not guilty, the accusation. So I would be okay without adding that particular charge, just for sake of time, if defense. counsel is
All right.
okay with it.
Same. I think it's pretty clear.
All right, so we got, and you're fine with jury as a trier of facts, because that would be like number 4.
Yes, ma'am.
Okay, and let's see. We don't have direct and indirect.
I think she puts in the evidence, hold on, there's an evidence portion, I think she
Is it-
discusses
I think it's
direct
the-
and circumstantial.
Oh, wait a minute, yep, let's see, yep, okay, yep, there you go.
When direct evidence by inference, yes, ma'am.
And this is. And on the witnesses, that's fine for the witness cooperation, right?
From the state, yeah.
Oh, Ms. Berry,
Yes, Your Honor.
we got identification, did y'all want that?
I don't think.
Which one?
That's a 1.3510, identification and reliability of identification.
And the identification and really, no.
All right,
We're not arguing.
yeah, okay. Definition of a crime,
That's in there.
yeah, okay, let's see. Venue. I don't remember seeing that, hold on. Definition comes there, we don't apply consent. Oh, let's see, yeah, we don't have venue in there. Do you want the, let's see, pattern for venue and the pattern for sympathy?
I think
Well,
the sympathy's in there.
Covered in the.
Yeah,
And
but yes, if your honor would like to get the venue generally,
do you want the,
yeah, the pattern chart that we have is perfectly fine.
all right, so we got the sympathy venue. Unanimous verdict deliberations. It's in here. Make sure we got everything. Yep, all right.
And it should be, yes, man, it should be like the
So-
second to last chart.
Yeah, there you go. So we'll just add the 1.51 to 10, that's venue. Is that good? So everybody's good, we add that and we'll be good, right?
Yes, Your Honor.
Okay. Add this real quick and then we'll be back and bring them in, charge them, and then close it. And then we'll let them go.
Oh, something going on. And I feel like they, that's what they did. So I think they did, right. Like, oh, what's, like, especially if they're like, oh, we have questions, Just feel like, I guess I didn't like going to. The court stuff yesterday, because he's mad because that she doesn't have. Normally judges have jury charts kind of. I just feel like we have some. Feedback here today, so I really want to move this quickly. So it would have been nice if it's like, oh, it could be done by lunch. So at least they're ordering the lunch so they can deliberate.
That's what
They have a break.
yesterday when we were saying like we can do it today. That's what that's gonna be done before lunch today.
Yeah.
Right. And I started late.
So we concluded that somebody threw some food or something in the trash can. For 5 minutes, given that, and we don't know how long we said. We don't know when we're gonna. So we can find that, but like, what, a month?
Ever since it really started.
Like,
That's crazy. Oh my God, don't you start that. We don't have to start that. Are you? He said, I'm out. You did a question. You did. What do you call it?
Are you gonna say? It doesn't matter.
So what you think?
You took judicial notice when you. Like, bro.
I was so confused for a second. I didn't know who raised you.
Y'all dress up for Halloween.
We gotta try 'em.
I didn't have anything to do with it.
Clearly. He said, no, tell me what the song is, I'll play it for you. I got, yes. Oh, back, oh my gosh. That's cute. You do. Rose. You are just my associate.
I'm a child.
I don't know, I'm just over here. Manifest and cook.
Yeah, it is.
I don't know. I don't like. Does she?
It's one job, it's one job, it's one time, I had some. No, I just want to look, I want to come out and leave it at work. I hate to get that real quick. I ain't had to worry about it.
Ms. Berry, I am forwarding you, I guess, a digital copy of the chart, I guess. The final
Okay.
ordinance.
Bro. No, wait a minute.
No, she looks very cute, but when you see her, it's like Felicia.
I just sent you an email.
I forwarded it.
I got it.
Oh, okay, because they told me you didn't have a computer, that's why I was like.
That's
Oh,
fine.
I'm just reading from my phone.
Okay, all right, let me know when you're ready.
Oh, I'm ready.
We're
We're
ready.
ready, you guys ready?
Yes, ma'am.
Perfect.
Because last time you jumped on and I couldn't get back up in it.
Oh, yeah, that's true. I remember that.
Yeah, they're having fun. Is it the jury room over here?
Feeling good.
How nice for them. I want.
I hate mine is rumbling over here. Oh, boy.
I know you don't have to tell me, but are you gonna open or just close?
So I will open close.
You open and close?
Yes, ma'am.
Yeah. Last month's the only time. I
You
did.
don't always do it. Sometimes you shake it up a little bit.
Okay, well, I'm gonna be open.
That's unusual.
I know, and D, I feel like it's very appropriate, and after we finish, I'll tell you why.
Okay.
Yeah, that happens at least when I'm doing trial, she's gotta send somebody back there.
No. And I forgot to take a picture. I'm not-
Why is it designed?
I hear it, I'll forward it to you.
With courtrooms, you think they would make this a little bit more
Correct,
insulated?
correct. Correct, and I don't know if you've been like back there, but it's
It's cold.
a very small little hallway, and then there's like a couple of cells on both sides. So they're like right on the other side of the walls.
Okay.
Here, there's your copy since you, oh, keeps getting Barry, since we emailed the final copy to him. Y'all saw the little part about venue, question, right? So since you didn't have your computer, I was like, okay.
So this is my copy.
Yes, ma'am. But you looked at what we emailed Mr. Hollins?
I forwarded it to her.
Yes, I read it from my phone, so I'm good.
Oh, you're okay.
Yeah.
So she'll print out 7 copies, but you got that one. Okay. All right. Yeah, Ms. Brock will bring, Ms. Davis will bring us the 7 copies. And then we'll get started.
Ready for you.
All right. Ms. Berry, you'll have a full house of trick or treating to do tonight, won't you?
Oh, yes. Yes.
All right, let's see.
That was like 10.
They're having technical issues, so she has to run down there to the big printer and grab them. You can tell them to fill up their waters or use the restroom. We'll bring them in through this and lunch should be here shortly.
Okay.
Judge Manning, please hold.
Okay. And the copy, Ms. Davis sent y'all had the little two paragraphs about venue, right?
Who?
Venue.
I will verify.
It may not be in the one.
Yes.
Yeah.
Yes.
Yes, ma'am.
You see it in there? Or added it to the end? Ms. Barry, it was on your phone. Is it on the one that's printed?
Yeah, I see it at the middle of page 5. Right before definition of a crime.
Okay. All right, let me see if I can help with some copies.
I'm so confused. What are we waiting on?
Just
Copies, I guess.
You can probably just go forward and then they can work on getting the copies and then when they send it back.
One would think.
Oh, and
They don't pay me enough. All right.
They seem happy about it.
Yeah, they're like alive.
Yeah, they seem like.
Yeah, they're very live. Last time I had jurors, they all chipped in and brought like a potluck.
Oh, really?
Yeah. Yeah, then you have some jurors that feel like they know everything. And those be the worst, because you explain to them, oh, yeah, they talk over you, and then when it get down to it,
Oh, yeah.
yeah, but they're laughing.
Yeah.
Yeah,
They seem happy to be here.
yeah, they're enjoying the experience, that's good. And then, I had jurors that left their numbers on the wall, and they became friends after.
Oh, really?
I was like, jury duty, what a fun. Yeah. Okay, I have hers. Like you are so amazing. Just because it's like, it was a malpractice trial. It's literally for 2 weeks. And it's like babysitting. I'm like a host.
Yeah.
It's hard.
I did a 3-week medical malpractice trial
Yeah,
in this court,
yeah.
and there were 18 lawyers.
I can only imagine. If I was you, I would get off and I wouldn't want to talk. My lips.
I didn't even want to see people,
Yeah.
and every day would be Deputy Parker, you can get your both one of these for the final copy, and then you can bring the jury in.
Yes, sure.
We'll do the charge for them. Judge Ellen, she does it ahead of time, and then we'll let y'all close, and then we'll let them go.
Ready, Your Honor?
Yeah. All right, for the jurors.
Oh, no problem. All jurors accounted for, Your Honor.
All right. Ms. Hollins, you recognize this as your jury? All right, Ms. Berry?
Yes, Your Honor.
All right, all jurors are here and accounted for. All right, so, and is defense resting their case?
Yes, defense rests.
Okay, so that's the conclusion of the presentation of evidence. I'm going to read you some jury charges. They're going to do their closing arguments. We'll send you back to deliberate and eat your Jimmy John's.
Okay.
All right, all right. You also have copies of this back with you, okay? This is the state of Georgia versus Joshua Elijah White, accusation number 23 CR 006-398Y. I'm filling in for Judge Susan Edline. Ladies and gentlemen of the jury, you've heard evidence in the case of the state of Georgia versus Joshua Elijah White, whose accusation number 23 CR 006-398Y as in Yankee is charged with 1 count of driving under the influence less safe to drive and 1 count of open container of alcohol, which are misdemeanors in the state of Georgia. To this accusation, the defendant came into court and pled not guilty. The accusation, together with the defendant's plea of not guilty, form an issue that you are determined. The accusation and the plea of not guilty are not evidence and should not be regarded as evidence by you. I will now charge you with the law which you should apply to the facts as you find them to be from the evidence presented. You should consider these charges along with those I have previously given you. You will be given a copy of the charges to have with you in the jury room. Presumption of innocence. The defendant enters this trial in this case with a presumption of innocence in his favor. And that presumption remains with him throughout the trial of this case until and unless the state produces evidence in your presence and hearing sufficient to satisfy your minds beyond a reasonable doubt of the defendant's guilt of the offenses charged. Burden of proof. No person shall be convicted of any crime until each element of the crime is proven beyond a reasonable doubt. Facts and circumstances which merely place upon the defendant a grave suspicion of the crimes charged, or which they merely raise a suspicion, speculation, conjuncture of the defendant's guilt are not sufficient to convict. The burden of proof rests upon the state to prove every material allegation of the accusation and every essential element of the crime charged beyond a reasonable doubt. There is no burden upon the defendant whatsoever, and the burden never shifts to the defendant to prove his innocence. Defendant in a criminal case is under no duty to testify, or present any evidence tending to prove his innocence. If he elects not to testify, no inference, hurtful, harmful, or adverse to the defendant shall be drawn by this jury, nor shall such fact be held against him in any way whatsoever. Reasonable doubt. While the law of the state requires to prove the defendant's guilt to your satisfaction beyond a reasonable doubt, the law does not require the state to prove the defendant's guilt to an absolute or mathematical certainty. A reasonable doubt is just what it says. It's a doubt of a fair-minded, impartial juror honestly seeking the truth. It's a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which a reason can be given arising from consideration of evidence, lack of evidence, a conflict in the evidence, or any combination of these. Simply stated, it is a reasonable doubt of a juror. If after giving consideration to all the facts of this case, and if your minds are wavering, unsettled, or unsatisfied, then that is doubt of the law, and you should acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you'd be authorized to convict the defendant. Jury as a trier of fact, you are the judges of the facts in this case. The facts you obtain from the evidence produced to you. The law you take from the court is given to you by a charge by the court. Any verdict in which you may render in this case should be derived from the facts you find them to be, applying the law as given you in this charge. It should be a verdict that speaks the truth. Evidence. The fact that the cases are to be determined by you from the evidence. Evidence consists of the testimony you've heard under oath and exhibits which have been admitted and will be with you in the jury room during your deliberations. Direct evidence is that which may be seen or heard otherwise directly sensed by smell, touch, or taste. If it's brought to you in the court form of exhibits or testimony of the direct witness to such matters, it's the evidence that points immediately to the issue in question. When direct evidence by inference points to an obviously likely or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you infer other related or connected facts that are reasonable and justified in the light of your experience. If the evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions, sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proved fact must not only be consistent with the theory of guilt, but exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based on circumstantial evidence than upon direct evidence. Whether dependent on direct evidence or circumstantial evidence or both, the test is whether there is sufficient evidence and whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you must convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the whole jury to decide. Witnesses. You're required to accept the testimony of any witnesses. Testimony of all witnesses is to be given only the weight and credit as you think it's properly entitled to receive. The jury must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their means, opportunity of knowing the facts in which they testify, the nature of the facts in which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Your assessment of trial witnesses' credibility may be affected by comparing or contrasting the testimony to statements or testimony of the same witness before the trial started. It is for you to decide whether there's reasonable explanation for any inconsistency in a witness's pretrial statements, testimony when compared to the same witness's trial testimony. As with all the issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. To impeach a witness, sorry, Judge Edline's monitoring my progress and sent me a message. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. In determining the credibility of the witnesses and testimony by them in court, you may consider where applicable evidence offered to attack credibility or believability of any such witness. Venue, the law provides that criminal action should be tried in the county in which the crime was committed, except otherwise provided by law. In the prosecution of this case, in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in the county which the evidence shows beyond a reasonable doubt that it may have been committed. Venue, that is, the crime committed in Fulton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt of any element of the offense. Venue must be proved by direct or circumstantial evidence or both. Definition of a crime. The defendant is charged with a crime against the laws of this state. A crime in violation of the statute of this state is where there's joint operation of an act or omission of an act and intention. And criminal intent, I charge you that intent is an essential element of DUI and must be proven by the state beyond the reasonable doubt. Criminal intent does not always equate to a mental fault, guilty knowledge, or purposeful violation of the law. Criminal intent does not always mean an intention to violate the law, but simply means to intend to commit the act which is prohibited by the statute. Intent may be shown in ways provided to you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by the acts and conduct, or it may be, in your discretion, inferred from when it is natural and necessary consequences of the act. Whether or not you draw such inference is a matter solely within your discretion. To prove DUI, the state need not prove that defendant intended to commit the offense of driving under the influence, but the state must prove the defendant's condition of being under the influence of alcohol to the extent of impairment, and while in this condition, the intent to drive. This general intent may or may not be inferred from conduct of the accused in other circumstances. Driving under the influence of alcohol, less safe to drive. Shall be unlawful for any person while under the influence of alcohol to drive or be in actual physical control of any moving vehicle anywhere within the state. A driver or operator of a motor vehicle is under the influence of alcohol when the person is affected by alcohol to the extent that it is less safe for the person to drive than it would be if the person were not affected by alcohol. A driver who is less safe is less efficient, less skillful, less coherent, less able, less qualified, and less proficient. In deciding this issue, you may consider anything in the evidence that you find relevant in deciding whether the defendant was a less safe driver. Specifically, as a consumption of alcohol, you may consider, among other factors, the smell or lacks of smell of alcoholic beverages on the defendant's breath and or his person, and whether any tests indicate the presence of alcohol in the defendant's system. As to whether the defendant was left safe to drive, you may consider the factors you deem relevant, including but not limited to the actual manner of driving of the motor vehicle, the defendant's control of his mental or physical abilities, the defendant's demeanor, the physical condition of the defendant, and any testimony. We missed the one. Merely showing that the defendant had been drinking or there was a smell of alcohol on the defendant's breath or person without the proof of the manner of driving ability to the drive is insufficient to prove that the defendant was guilty of driving under the influence of alcohol. A witness who satisfactorily shows that he had the opportunity to observe and did observe the defendant may testify and render his opinion as to whether the defendant was under the influence of alcohol, whether because of intoxication or because the defendant was a less safe driver. While a witness may give his opinion as to whether the person was under the influence of alcohol, to the extent it was less safe for him to drive, that opinion must be supported sufficiently by evidentiary foundation. Pursuant to OCGA 46391, para 1, para A, para 1, the offense of driving while under the influence of alcohol to the extent that it's less safe has three elements. Driving under the influence of alcohol to the extent that it's less safe for a person to drive. This offense does not require the state to prove evidence of chemical analysis of the defendant's bodily substance as it relates to blood alcohol content. the Georgia implied consent law. A person who operates a motor vehicle upon the highways of Georgia or elsewhere throughout the state shall be deemed to have given consent to a chemical test of the blood, breath, urine, or other bodily substances for the purpose of determining the presence of alcohol. This test shall be administered at the request of law enforcement officer having reasonable grounds to believe the person had been driving a motor vehicle while under the influence of alcohol. This law authorizes law enforcement officer to designate the appropriate chemical test to be administered, breath, blood, urine, or other bodily substances for detection of the source of impairment as suspected by the officer. Defendant's right of refusal. While the Georgia implied consent law requires a defendant arrested for DUI submit to a chemical test, when properly requested to do so by a police officer, that person has the right to refuse to take any such test. The exercise of the right of refusal in itself is non-determined as to whether or not the person was under the influence of alcohol. Nor is the defendant's refusal alone sufficient to warrant a determination that he was driving under the influence to the extent that he was a less safe driver. Defendant's refusal to permit chemical analysis to be made of his blood at the time of his arrest is admissible in evidence against him in a criminal trial. This refusal may be considered as a positive evidence creating inference that the test would show the presence of alcohol. Such an inference can be rebutted. It is up to you, the jury, to determine whether the defendant refused to be submitted to testing. Field sobriety evaluations. In determining the defendant was less safe driver, you may consider the results of the field sobriety evaluations conducted in this case. Participation in sobriety evaluations is entirely voluntary. A person has a right to decline participation in the field sobriety evaluations. Field sobriety evaluations include the horizontal gaze and nystagmus, or HGN test. The HGN test is admissible as a basis upon an officer can determine the driver was impaired by alcohol. Other field sobriety evaluations, simply common sense evaluations of a subject's balance or motor skills. What inferences you draw from the performance of the HGN test or other field sobriety evaluations is entirely within your discretion. The results of the field sobriety evaluations, in conjunction with other factors, including physical appearance of the driver, the presence of the odor of alcohol, and any inculpatory statements made by the driver, may form an appropriate basis for an evaluation by an officer and ultimately a jury as to whether the driver was impaired by alcohol and to the extent it was less safe for him to drive. Possession of open alcohol, open container of alcoholic beverages. A person shall not consume any alcoholic beverages or possess alcoholic beverage in container in the passenger area of a motor vehicle on the road. An open alcohol beverage container means bottle, can, other receptacle that contains an amount of alcoholic beverage that is open or has the seal broken in which the contents are partially removed. All right, we'll go ahead and let you folks do closing, and then I'll do the concluding comments. State.
State will reserve this right, and wait to open close, we'll just close code.
All right, Sperry.
Right. Okay, we are in the home stretch, ladies and gentlemen. Since this is a short trial, everything urged to the past, 24 hours. I'm gonna keep this short, I'm not gonna subject you to some kind of multimedia PowerPoint presentation. I will do a little bit of recapping, but before I get to the facts I want to talk a little bit about the law. Particularly, I want to talk about the state's burden of proof in a criminal case. So, some of you said during jury selection, you had a jury, you were called as a juror not too long ago, and hopefully you're not called, knock on wood. Hopefully you're called not too soon after this. But I will say that this may be the only time in your life as a juror in a criminal case that you are going to make a decision in this way. You come back to court and you are selected for any other kind of case in this courthouse, like a civil prosecution, a civil case where there's a plaintiff and a defendant, two people are suing each other for $5 or $500 million or for property or land or just about anything else you could be fighting about in court. It's more of what you think of as the scales of justice. You hear from one side, you hear from the other side, you do a balancing, right? But in a criminal prosecution, the state of Georgia makes the case, right? And there's not that balancing. The state has to prove the charges, the essential elements of the charges beyond a reasonable doubt. And that burden never shifts to Joshua to prove innocent, to put up evidence, to testify, to say anything at all. Because the founding fathers of the United States of America and, and under Georgia law have said, when someone is charged as in a criminal offense, when life and liberty is on the line, you have to be really sure, right? I'd much rather, err on the side of someone who is guilty going free than of wrongly convicting an innocent man. So again, it's the state's investigation, the state's evidence, right? And similarly, it's a little bit different. It's a different framework. Again, this is the only time you're probably ever going to make a decision like this. If you were to leave court today and you stop at the grocery store and you buy toothpaste or you need toothpaste and you're looking at, one kind is the kind that you really like, it makes your teeth extra white, has a good flavor to it, but another kind, not quite as good, but it's on sale. Again, you do the balancing, but that's not the analysis we make. And it's hard to set that aside because that is the natural, way we make decisions on a day-to-day basis. So keep in mind though, the framework, you just heard the judge go over the law about, proof beyond reasonable doubt and what that means in the burden of proof. Happily have a packet of laws back there to refer to. But keep that in mind as you're going through your analysis, because that is the paradigm, the framework to which you make the decision. And also I want to say that's unsatisfying. I mean, it's unsatisfying for me as a criminal defense lawyer to have to explain that and say, oh, I'm not here to prove innocence. I'm not here to put up evidence. I'm not here to do that. I'm just here to hold the state to its burden of proving guilt beyond a reasonable doubt. But again, and we'll circle back to it, but this is the officer's investigation. The officer needs to put up this evidence. And it's unsatisfying. So I know I've talked a lot about reasonable doubt, but what does reasonable doubt mean? Well, reasonable doubt, as you heard in the law, and we could reference back to, it is just what it says. It's a doubt for which you can give a reason, right? It's not a vague or arbitrary doubt. We're not talking about, well, maybe it wasn't Josh, maybe it was, green aliens from Mars, Mars who came down. We're not talking about that. We're talking about just a doubt of common sense or reason. And there are three words, which you should look for, again, it's in the law. If your mind is wavering, unsettled, unsatisfied. Like that's sort of the theme of this case, it's unsatisfying. It's unsatisfying to not know things, right? But if you're unsatisfied as to the evidence presented to you in this case, you're unsatisfied as to what you know about what happened that night, then that lack of satisfaction, that is reasonable doubt. So a tire uncertainty, if you feel like I'm on the fence, I'm not sure what to do, you know what that is? Reasonable doubt. You heard in the charge that you were given, they talk about, or the law is what we reference as grave suspicion. Even if you find the behavior gravely suspicious, something just doesn't sit right with you about, okay, it's 5 a.m, there's a bottle of liquor, grave suspicion, that's still reasonable doubt, right? It's not proof beyond a reasonable doubt, you still have that doubt. If you just wish you knew more, if you just said, well, I still have a lot of questions. You know what having a lot of questions is? Having a lot of questions is reasonable doubt. Even if you think, well, he's probably guilty, probably drank, probably out doing something, probably reasonable doubt. Assumptions, conjecture, all reasonable doubt. So again, I know I probably thinking, oh my goodness, she's beating a dead horse here, but again, it's so important that we view this case from this correct framework. The other, and I'm going to go through some of the reasonable doubts in a moment, but the other part of the law I want to talk about is this concept of what they call DUI alcohol less safe. And when you get the verdict form, that's the main charge in the case. There's also open container, which I'll come back to too, but the DUI alcohol less safe. That's the way, people think about drunk drivers and stuff, right? But that's not what we're actually deciding here, and only lawyers and legislators would use the term DUI alcohol less safe. They make it really confusing, right? Because I hear the term, gee, was this less safe, right? Was this less safe driving? Yes, of course it was. Was I a less safe driver this morning because I'm nervous about this trial coming to court? So I'm distracted, it's Halloween and there's a lot of stuff going on in my kids' school and everything. Yes, I was a less safe driver. Is pretty much anybody who's in a car accident, especially a not fault driver, which you seem to be, are they a less safe driver? Yes, right? So we are conceding that Joshua was a less safe driver, but the state has to prove not that he's just a less safe driver, but that he was a less safe driver because he was under the influence of alcohol beyond a reasonable doubt. Now, Could there be alcohol in the system? You know, is there evidence where there's presence of alcohol? Sure, but again, the state has to prove beyond a reasonable doubt he was under the influence of alcohol to the extent that made him a less safe driver. Not just that he was a less safe driver. Anybody in a car accident, as I said, is a less safe driver. So again, break that down because it's very I feel like cumbersome wording. And the state may get up here and say, well, look, we don't have to prove that somebody is drunk. We don't have to prove that somebody's fallen down drunk, right? But they still have to prove that somebody is impaired. And just because you consume alcohol, just because you have consumed alcohol, just because you're a wreck, that doesn't mean the state has proved impairment beyond a reasonable doubt, that you're impaired by alcohol. So keep that in mind. Okay, so let's talk about some things. We have the driving, as I just mentioned, that's certainly less safe driving. But rear end collisions happen all the time. We talked about that during jury selection. You can be in a car accident. That doesn't mean it's because you were under the influence of alcohol. The officers even, begrudgingly admitted that. Alcohol, rear end collisions, extremely common in Metro Atlanta. And also too, this is 5 a.m. People could be tired, people could be dozing off a little bit. There could be lots of reasons absent, why somebody, absent being under the influence, why this could happen. All right, so then let's talk about this investigation or lack thereof. I think there's a lot of just helpful information that could have been easily ascertained if just a few questions were asked. I mean, I would have wanted to know as as an officer, and again, it's the officer's investigation. They're the ones who have to get the evidence here. Where was he coming from? Was he dropping someone off? Where was he going? Did he admit that he was drinking? I mean, I suspect that the state is going to start talking about, oh, there was a liquor bottle and a red Solo cup in the car. I guess their argument is that Joshua at 5 a.m. is driving around Atlanta and drank half a bottle of tequila. But just because, again, there's alcohol in the car, that doesn't mean that, we don't know anything about who consumed the alcohol, when it was consumed. Maybe it was from, last week. Maybe there was other people. Maybe he was driving people home. Maybe he had been the designated driver and was making sure people got home safe. There's just a whole lot that we don't know. And a few simple questions, in a police investigation could have answered that. And that just wasn't done. Also too, I would say the video is an evidence. So the state sometimes may show, portions of it that are unflattering to Mr. White. But at any point in time, you want to see a portion of it. You can knock on the door and ask the bailiff and they will bring you back out and they'll put it on the big screen and you can see. So you don't have to take, my word for it or anything. You can go back and watch any portions for yourself. But I'll submit this to you, on the walk and turn or one leg stand, does he look great? No, he can't do the one leg stand, which I'll come back to. That's tough. But in general, he's standing up, he's walking around, he's following instructions, in regard to his demeanor. I wish there was some more conversation. I wish there was the ABCs and 1, 2, 3s and who's the president, and what time is it, and some other things to just engage in conversation. But he's not giggly, he's not belligerent, he's not cussing, he's not being rude. He's not I guess again he's not being disorderly. I think the officer said, oh, he was swaying. And when I watched the video, he's standing up, like when he's doing the eye test, he's following the stimulus. He appears to be standing up straight. Certainly not the way you would expect, someone to be behaving if they were driving around drinking, half a giant bottle of tequila. So I think that he looks, normal and sounds normal and is appropriate on the tape. And as I said, the officer doesn't ask what I also call, in addition to the kind of the time frame stuff, but also just kind of like the baseline questions. Like, is he someone who is, educated? Is he somebody who, is he from the area? Is he just here visiting? There's not any of these basic things that could have helped in an investigation if you're actually trying to build a case with proof beyond a reasonable doubt that you're under the influence. I also want to say that there was no, the officer said, well, we asked him if he needed medical assistance and he said no. Sometimes people could be concussed or have different medical issues, which if they're shaken after being in a car accident, they don't necessarily realize at first. It's not necessarily apparent. And that could also be some of the things that are coming into play here. I do want to say, a word about Trooper Fernandez, well, and I guess both officers. And it's that I don't think that they're bad officers, or actually they seem like they're very, good and, nice officers. But I do think that they have a confirmation bias, right? They have a hard job. They're both really new, first year kind of rookie cops. You heard who was Officer Fernandez's first arrest. And he comes out to a situation and, you never really know what to expect, right? Sometimes you have people who want to fight you or stab you, or, you're working all different kinds of situations. There can be belligerent people, there can be people who are seriously critically injured. So you're walking into difficult situations, but I do think that they have, an element of confirmation bias. And you heard from, I think what the first officer is Officer Lane, and he said, oh, look, it's, it was after midnight. If it's after midnight, people are probably coming from the bars or the clubs, so I'm kind of assuming it's alcohol. And I think everybody has their confirmation bias, right? Everybody has confirmation bias in their lives about things they're assuming. So I'm just saying that if you have a young man, it's 5 a.m, there's an accident, and then they see a bottle of, tequila in the car. I mean, I think that there's almost no way he's not being arrested, no matter, how he performed on the field sobriety test, because they have that idea. And, you saw basically the entire investigation on the video, it took about 15 minutes, and they made up their decision, and that was it. But, not everybody always gets it right, right? I don't always get things right in my job. But at the end of the day too, it still comes back around to, it's the officer's investigation, their job to prove their case beyond a reasonable doubt. The state makes the charges and they have to get the evidence that they need. Let's talk about the HGN test. So you heard that, these field sobriety tests are all voluntary. Somebody can say, no way, I'm not doing them. But, Josh does do them and gets through them. And I think on the horizontal gaze nystagmus, it looks like, he followed instructions, he stood up straight, he followed the stimulus, he did what the officer, he looked fine doing, the evaluation on the tape to me. Now, of course, I wish he was turned the other way so we actually could see his eyes. That would be helpful. If the officer's saying he's looking for this nystagmus, this jerking. But then you heard the officer on the stand and say that there's lots of other things, he admitted there's lots of other things that can cause the jerking of the eyes, including flashing lights, including certain things, I asked about fatigue nystagmus and he was like, oh yeah, okay. So I think that just because if you see some jerking in the eye, that doesn't mean, that's a fail-proof test to say, oh yes, that's because somebody's under the influence of alcohol. And actually, he said when he was doing these kinds of passes, the vertical gaze nystagmus, which is supposed to show a high dose of alcohol or intoxication for a particular person, he didn't even see the jerking. So I would say that, we can't see what he saw. I wish we could. But based on, I would say, his lack of experience, and then a lot of the other, he said he turned off his lights, but you can go back and look at the tape. There were lots of other flashing lights. There was lots of cars coming by. It's a busy area. I wouldn't say that this test in and of itself is particularly indicative of very much. And then I'll kind of group the walk and turn and the one leg stand. These are both dexterity tests, and I would say that they have kind of a convoluted scoring system. And I think that there's people who, on the best day of their life, on their birthday in their backyard with their friends around, would maybe have difficulty balancing on one foot for 30 seconds. And I feel like it doesn't take nerves in the situation into account. Again, we don't know for certain if he, if Josh had, some kind of concussion or anything, but we do know that, I think it's common sense that if you crash your car, if you got hit in the face with an airbag, just a few minutes before this, the adrenaline is probably, pumping. I mean, I crashed my car on 285 a few years ago, during the day, I was at fault. I wasn't under the influence. Thankfully, everybody was okay. But when I got out of the car, my airbag deployed, I wasn't, seriously injured, just maybe some airbag burn. When I got out of the car, I was like shaking. Actually, another driver stopped, got out and hugged me because I was just so upset, right? Though not hurt. So I just feel like to go through something like that and then to be asked to do field sobriety and be asked to balance on one foot, I think that would be hard for almost anybody to do well. I wouldn't say that's an indication beyond a reasonable doubt that somebody's impaired by alcohol. I guess lastly, I just want to touch back on, the blood. Lack of blood tests. You did hear that the officer read, after we arrested Josh, he would put him in the patrol car and then asked him if he would take a blood test. And you'll see that, because it's in evidence, the card he read. And Josh said no. I think the state will argue, oh, well, he said no, that's on Josh. But again, burden of proof. And it's never Josh's responsibility to provide evidence, to provide a test. you have a borderline case, you have a lot of uncertainty. It's the officer's job that he could get a blood test. He could get a warrant and get a blood test, especially if they went to the hospital. Actually, they were at the hospital. It would have been easy to get a blood test. And the officer didn't do that. And if that was needed for their investigation, again, it's the state's case, and that wasn't done. So, you know, based on that, you know, we don't do convictions based on assumptions and probablys and conjectures, and I wish we knew more. If you have questions, if you're unsatisfied, that's reasonable doubt. And with reasonable doubt, that means, you know, as the DUI charge, we ask that you find, not that we ask, it would be your duty under the law, if there's reasonable doubt, find Joshua not guilty of DUI. I will say as an open container, you know, is there evidence there was an open container in his vehicle? I don't think that there's reasonable doubt there. I think that the state probably has proven their case. So as an open container, if you want to find him guilty, then I think that, you know, there's evidence. But again, that's your decision to make. Thank you, ladies and gentlemen.
All right. Mr. Hollins?
Yes, Your Honor. Yes, I am gonna bore you with a long conversation.
Oh, my.
I do feel it appropriate that you see these things in conjunction and not the spaghetti that's being thrown at the wall right now. So we're here again to discuss State of Georgia versus Mr. Joshua White. He's currently charged with DUI less safe and possession of open container of alcohol, both misdemeanors in the state of Georgia. For DUI less safe, let's delve into this. There's a lot of words that were thrown at you all recently between the jury charges and defense counsel closing. So I want to hone in on the important things and keep you all focused. A person shall not, when you see the word shall not, it means you cannot drive or be in actual physical control of any moving vehicle while under the influence of alcohol to the extent, and this is the important part, that it is less safe for you to drive. Less safe means less efficient, less capable, less skillful, less competent, less qualified, and less proficient. What it does not mean we have to show is that the person is fall over drunk, falling out of their car, vomiting all over the place. We do not have to show that because you can be impaired and less safe to drive without being. The trier of fact, that is you, ladies and gentlemen of the jury. You can determine whether or not somebody is less safe by making observations of impairment. So not only the observations that you saw with your own eyes when we played the video, but also the observations that you can't see with your own eyes, that the trooper and our officer, Officer Lane, testified to, wrote in their reports, so that when today came, they would have a memory and the ability to recall these things that they observed on the scene shortly after it happened. You can look at the demeanor, the appearance of the defendant, his speech, his decision-making. There is no requirement of a chemical test under a DUI less safe statute. I want to make that very, very, very clear. The state does not have to produce any type of chemical test. The law doesn't require us to. And I also want to say that the state is not required, sorry, the officer is not required to go get a search warrant. They asked the implied consent, which our officer did. It is the defendant's choice whether or not he would like to produce that result or not. If he does not, the officer continues on with what he's going to do. Possession of open container of alcohol. I don't think there's going to be much of a dispute on this one. You cannot consume any alcoholic beverage or possess an open container where the seal has been broken. Now, alcoholic beverages could be a couple of different things. They could be beer, they could be wine, they could be malt liquor. There's a bunch of different things that the statute gives, but for our purposes, we've got an open bottle of 1.75 liters of Casamigos, which is tequila, which we know to be an impairing substance. Now, the passenger area doesn't necessarily mean in the passenger area. It means anywhere that's accessible in the car by the driver or any other passenger. And notice we don't have any other passengers in the vehicle. So the only person that's able to access that particular bottle would be Mr. White. Beyond a reasonable doubt. So again, it is doubt of a fair-minded, impartial juror honestly seeking the truth. But what I want to tell you is, it doesn't require us to show beyond a mathematical certainty 99.9%. We don't have to show anything other than if you have a reasonable doubt. We don't want you searching for doubt, creating doubt. It is a reasonable doubt that comes into your mind based on the evidence that's presented by both myself and Ms. Barrett. And if you can reasonably conclude, even with the questions that you may have, based on the circumstantial and direct evidence, that Mr. White is guilty, you are allowed to find that we have proved our burden beyond a reasonable doubt. Now let's go into the facts that we established. So we have the initial encounter with Officer Lane. Officer Lane stated that around 4 or 5 o'clock in the morning, early in the morning, there was an incident that occurred at I-85 Jordan 400 northbound. The dispatch came in, the officer shortly arrived, and he determined, based on his investigation of talking to all parties at scene, that the defendant was at fault for the collision. And we don't call it an accident because when you get in the car, you drink and you drive, and you're driving to the extent that you're a less safe person and you cause a collision, that is not an accident. Now he has contact with the defendant. Officer Lane makes contact with him. He's asking him questions. His story's not making sense. Yes, he didn't ask him where he came from, but when he was trying to talk to him, the defendant was being evasive. He wasn't answering the questions. And it's kind of easy to say that he didn't know much of what was going on at that particular moment. He was having trouble with doing basic things like putting his shoes on the right feet. This is when Officer Lane becomes suspicious. He observes a strong odor of alcohol, and he classified it as strong. He told you that we walked around a couple of different areas. It wasn't just inside the car where the big bottle of alcohol was. It was also away from the car when he got Mr. White away from the car and started speaking with him. He saw and observed the red Solo cup on the ground next to the vehicle. And at this time, because he was not trained as a DUI certified officer, he called somebody who was. And why? Because he wanted to make sure the appropriate investigation was done because there was an accident. So what does he do? He calls Trooper Fernandez. Trooper Fernandez is a standardized field sobriety trained officer. He's worked the actual incident itself while Officer Lane worked the collision. What observations did Trooper Fernandez make? The strong odor of alcohol, still. Watery and reddish colored eyes. The smell of alcohol coming from the defendant's breath. The fact that he had a slight sway when he was standing there. He said it multiple times, even on cross-examination. He stated, yeah, no, he was swaying. And if you pay attention to the video, you can see as he's standing there getting the shirt, there's a slight sway. He was polite and he was respectful to Mr. White. At no point did you hear him raise his voice. At no point did you ever see him screaming at him, threatening him, or anything like that. Why would he be nervous? I understand there's an accident or a collision that occurred. I understand there may be consumption of alcohol. But he was polite and respectful and gave him each opportunity and even asked him multiple times, are you okay? He then requested the field sobriety evaluations. Medically cleared him. Defendant didn't complain of any head pain, any neck pain, any leg injuries. He stated he didn't wear any contacts or glasses at the time. He was also cleared by medical staff at the hospital prior to being taken to the jail. So not only did Trooper Fernandez medically clear him on the scene in the limited capacity he could, but he was also taken to Atlanta Grady, and he was taken to the medical staff and cleared by medical staff, which he tells you is a requirement before they take somebody into custody when there's been an accident. Then he goes on to the HGN. The HGN can be very confusing. The horizontal gaze nystagmus, there's a lot of big words being thrown out. But the biggest thing is that, ladies and gentlemen, it is an involuntary reaction to the consumption of alcohol. The clues that he observed indicate that that person has had enough alcohol to cause that nystagmus, which is that involuntary jerking of the eyes. Think of it as a windshield wiper on a dry window. If it's raining outside and your windshield wipers are on, it goes smooth. But as soon as you stop the rain and your windshield wipers are still going, that's what the officer observes. it is incapable of being controlled by the person that it is happening to because it is a biological reaction to the
To
action.
objective facts, not an evidence.
It was he did state it was an involuntary jerking of the eyes, Your Honor.
I believe you did, Ms. Berry.
It is an involuntary jerking of the eyes caused by the consumption of. Now, we get to our walk-in turn. 5 out of 8 clues. And you can see here that he did each of these things multiple times. But as Trooper Fernandez explained on the scene, he didn't count every single one of them. That would be unfair to the defendant. If we had 18 different potential clues, and he counted it each and every time. But no, the standardized way that the people who came up with it required it to be done said you count it 8 times. There's 1 clue for each of these things he messes up on, even if he messes up multiple times. So he was given the benefit of the doubt from the beginning. He raises his arm. He steps off line. He misses heel to toe. He begins too soon. He has a difficult time following instructions. And Trooper Fernandez stated it multiple times. He didn't follow my instructions. I asked him to get there and you would see him get out of it. He would have to ask him to get back into that position. So ladies and gentlemen of the jury, I submit to you that the fact that Mr. White was incapable of following instructions is another sign that he was impaired.
What the fuck?
So I apologize. I have no clue what that was. All right, so now we get to our one leg stand. And our one leg stand, very similar. You see multiple clues of impairment. And this time there's 4 different clues that could be observed. And 3 out of those 4 clues were observed. And as you notice, Mr. White was unable to, as soon as he tried to raise his foot, he came down. Now I can understand if somebody was incapable of doing that. And every once in a while they're coming down because it's a little bit hard for them. From the very get-go, his leg goes up and it goes right back down. And you just constantly see go up and down and up and down. And ladies and gentlemen, the more alcohol you consume, the more you're gonna sway, the more you're gonna lose your balance. It's difficult for you to be able to do that when you're impaired by alcohol. Now, I want to preface this by saying Mr. White has 0 burden of proof. He doesn't have to prove anything. However, based on what we see in the evidence, and based on the theory of the case, of the way the defense counsel says it happens. Well, we have some issues with their theory of the case. Mr. White never complained of pain. Even throughout the evaluations, he never stopped the evaluations to say, hey, I'm not feeling good. This doesn't hurt, that doesn't hurt. He was being evasive with his stories. But for defense counsel, he wasn't giggling. Nobody else was in his vehicle. He denied having any previous injuries. He didn't follow the instructions during the field sobriety evaluation and was given these instructions multiple times. For example, somebody is supposed to hold their head still, and Trooper Fernandez told him multiple times, hold your head still, keep your head still, look directly at my pen. But because of Mr. White's level of impairment, it made it more difficult for him to follow those instructions. They're claiming a lack of investigation. One thing that I noticed that the defense counsel did not bring up at one particular time in her entire closing was the fact that we, number one, have the odor of alcohol. Let's not forget that. We don't have just an accident that the defendant caused. We don't have just the 3 field sobriety evaluations that arguably don't look good at all for the defendant. But we also have the strong odor of alcohol emitting from his breath. We forget to discuss this. They want to say it was because he was a newbie officer. And the officer stated he didn't shy away from that. And our initial officer even said, I didn't want to do it because I wasn't as trained. I wasn't trained. And there's no requirement for us to go get a search warrant. So ladies and gentlemen of the jury, the defense's theory of the case has flaws. Again, we're not required to show that he's fall over drunk. DUI less safe doesn't even require us to show a less safe driving act. But yet we do have one. We have the fact that he caused a whole rear end collision with disabling damage to every vehicle. Again, let's not forget this. The reason why these field sobriety evaluations are performed is because they mimic essentially the exact same things that we're doing while we're driving. We're looking at multiple different things. So the fact that Officer or Trooper Lane is asking, Trooper Fernandez, excuse me, is asking the defendant to do all these things at one time. I need you to put your leg on the line. I need you to keep it there. I need you to listen to my instruction. I need you to not move until I say go. All these things are mimicking what we're doing when we drive every day. That's why they're important to us. That's why the state uses these and relies on these. Because these things mimic exactly what we do when we're in the car. And alcohol affects our body's ability to react quickly to these things that we have to consider. A prime example is a person who cannot stop in time and causes a rear end accident. And ladies and gentlemen, I love to use the example. There's two examples I love to use. The defense's theory is that we believe he drank half the bottle. Personally, I don't believe that he would be standing if he drank half the bottle. But I'm saying that he probably drank enough of it to be a less safe driver. And what we will say is, I could be the greatest driver in the world. Best driver. I have NASCAR. I've never gotten a ticket in my life. So on a scale of 1 to 10, 1 being a terrible driver, I get in accidents every time I'm in the car. And 10 being I'm a great driver, I could be a 10. And if I have one drink, I move down and I become less safe than I was before when I was at a 10, prior to me consuming that alcohol. That is a great way to understand less safe. That is what it means to be less safe. Now, so why do we care about all these things? Again, driving requires a lot of things working together. We're not just looking at what we see, but what the impairment did to Mr. White's ability and his judgment when driving. It decreases the person's ability to react to situations quickly while driving. For example, paying attention, your motor functions, those are your standardized field sobriety evaluations. Paying attention should be inability to stay in lane, but inability to stop. Involuntary motor functions, HGN, things happening that we can't control. So, ladies and gentlemen, again, I just want to clear up what we saw during this trial. We saw a collision. We saw the scattered story of the defendant. We saw that he had balance issues. We all saw that he had the inability to follow instructions, the strong odor of alcohol, the slurred speech, the open container of alcohol sitting within arm's reach of the defendant, the red Solo cup. Ladies and gentlemen, those things, all those observations point to the fact that he was a less safe driver. And what we don't see is any indication of injuries. And I want to discuss circumstantial versus direct evidence. While we didn't see any alcohol going into Mr. White's body, nobody observed him drinking. Just kind of think of it like if you go to a gas station and you know you got to put gas in your car because your needle's on low. And so you swipe your card, you put the nozzle in the tank, and you watch the numbers go up. They're going up, going up, going up, and a little bit more because gas is expensive right now. But you never saw the gas go into the vehicle, but you know based on all the other things around you and the fact that your gas needle is now in full and the numbers have stopped going up, you know that your tank is full. You put gas in your car. Very similar to the fact that we don't have to see Mr. White driving the vehicle when he's the one stepping out of the driver's seat. We don't have to see him consuming the alcohol when there's a strong odor of alcohol coming from his breath. That's what I want you to think of as direct and circumstantial evidence. You use all of that in the totality of circumstances to determine whether or not, or should I say that Mr. White was impaired to the extent that he was a less safe driver. Now, again, bringing it full circle, I asked a couple of people during jury selection, including our bartender or former bartender, what are the observations and the signs and the things that you see when you take keys away from somebody? And the reason I asked you those is because I want you to be looking for those things prior to coming into the case. I want you to say, well, we talked about that before. We talked about the slurred speech, the odor of alcohol, the unsteadiness, the swaying. We talked about those things. And that's exactly what we saw when we watched the video. What other witnesses saw. And we don't want you to abandon your common sense. Ladies and gentlemen of the jury, at the end of the day, the defendant was less efficient. The defendant was less skillful. He was less competent, less capable, less qualified, less proficient. Ladies and gentlemen of the jury, Mr. White was less safe that evening. And the only verdict that the evidence will come in is a verdict of guilt. Thank you.
All right. Just read you a few more things and then we'll get you guys back so you can have some lunch. All right. Your verdict should be a true and correct verdict based on your opinion of the evidence according to the law that is given to you in the charge. In deciding facts of the case, you must not be swayed by bias, prejudice, sympathy in favor of any party. Our system of law does not permit jurors to be governed by prejudice, sympathy, or public opinion. Both of the parties and the public expect that you will carefully and impartially consider all of the evidence in this case, while the law is stated by the court, and reach a just verdict regardless of the consequences. All persons stand equal before the law, and in courts of justice, all persons are to be dealt with as equals. You may use your common sense, common knowledge arising at your verdict. You are not required to put aside these elements of your reasoning ability during your deliberation. You are also permitted to draw from the facts in which you find to have been proven any reasonable inferences as justified in light of your common experiences. You're only concerned about guilt or innocence of the defendant. You're not to concern yourself with anything concerning punishment or sentencing. The form of the verdict that we're going to send back, if after considering your verdict during testimony, you together with a charge of the court, you will find and believe beyond a reasonable doubt that the defendant in Fulton County did on or about May 29th, 2022, commit the offense of driving under the alcohol less safe, open container of alcohol as alleged in the accusation. You'll be authorized to find the defendant guilty. In the event that your form of the verdict will be, we the defendant find the defendant guilty on the particular counts. If you do not believe the defendant is guilty of any of the offenses, or if you have any reasonable doubt as to the guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict should read, we the jury find the defendant not guilty of the particular count. The verdict form should be self-explanatory. The verdict's in writing. Now, whenever your verdict's in the case, it must be unanimous. That is agreed by all of you. It must be in writing, dated, and signed by one of the jurors whom you select as a foreperson. It must be returned and published here in court. The court has no interest in the case. By no ruling or comment I may have made during the progress of the trial has the court intended to express any opinion upon the facts of the case, upon the credibility of witnesses, or upon the evidence or the guilt or innocence of the defendant. The court's interest in this matter is that the case be presented according to law and fairly, and that as honest, conscientious, and impartial jurors consider the case as the court has instructed you and return a verdict that speaks to the truth as you find the truth of the case to be. My final instructions for you. One of your first duties in the jury room would be to select one of you as a foreperson to preside over the deliberations, to sign the verdict to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's view. Each of you decide the case for yourself, but you should do so only after discussion and consideration of the case with the other jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should never surrender honest convictions, opinions in order to be congenial or reach a verdict solely based on the opinions of other jurors. I'm going to release you to the jury room, but please don't begin deliberations until you receive the verdict form and the exhibits, which I will send you shortly. You may begin your deliberations. If you have any questions during your deliberations, write them down and please give them to Deputy Parker. If you wish to take a break during your deliberations, you can do so at any time. And please understand that you may deliberate only when all of you are together as a group in the jury room. And Deputy Park, if you knock on the door, she'll hear it. She'll come get anything for you. Now, I need just our alternate, Mr. Nicholas Lofton, to hang back. And the rest of you can go to the jury room, and Mr. Lofton, you'll be able to go back and get your lunch after I finish speaking to you. He's not in trouble.
All right, for the jurors.
You did order lunch, right, Mr. Lawson? You ordered lunch, right? Okay. So, Mr. Lofton, since you were selected as an alternate, I'm going to allow you to leave so you can grab your lunch and you can leave. We appreciate your service as a juror. I'll remind you as instructed, you still don't talk about the case with anybody. In the unlikely event that something happens with one of our jurors and they get sick and they have to leave, we'll call you. So, yeah. Do you have, we'll give you this piece of paper, give it to Deputy Park, you can write a number on there and we'll call you and let you know that you need to come back. And it's unlikely that anything will happen. So I'll call you at the end of the trial, and once they've reached a verdict, and let you know you're excused and you can talk about it. Okay, but you can go back once you write your phone number down and grab your lunch and enjoy the rest of your day and your $25. Yeah, so you can go back and grab your lunch and then you can leave, Mr. Lofton. Thank you so much and thank you for your jury service. All right, anything else from the state?
Nothing to say, Your Honor.
Ms. Berry?
No, Your Honor.
Okay, and you've already approved the verdict form, so we'll send the verdict form and the jury charges back with them and let them go. We'll call you when we've got a verdict. I know y'all probably want to go eat lunch, right? Or something.
Well, planning on staying around the courthouse.
Yeah,
Okay.
we'll be here.
Okay. Well, Ms. Clark has our number, so if we get a question or a verdict, we'll.
Sure.
Short phone call away.
Okay, sounds good. So the court will be in recess until we have a verdict.